All set.
Okay. I'd like to call the meeting of the April 2018 Tennessee Real Estate Appraisers Commission. Roxanna, do we have a quorum?
We do, Mr. Chairman.
Do you need to take roll?
Yes, I do. If you don't mind, let me start. Randall Thomas.
Here.
Rex Garrison.
Here.
James Atwood.
Here.
Mark Johnston.
Here.
Jason Bennett.
Here.
And not present, we have Rosie Johnson and Dr. Warren McCara. We have quorum. Thank you.
Thank you. First on the agenda is the adoption of anybody have any current agenda?
Moved. Second.
We have a motion second. All those in favor say aye.
Aye.
All right. Any opposed? No. iPad, any corrections or additions to that?
Move we accept the minutes.
Thank you. Second. Motion's been made and second to accept.
Aye.
Any opposed? Okay, report experience.
Your report is on page 17 on your iPads, and I'll let everybody get to that. I don't believe we were able to interview everyone. I think one of them didn't have the necessary documents. I do want to take a quick minute and interrupt. I think everyone here is aware Dennis O'Brien's no longer with the board, and so we are missing him. So if you have any calls, emails, questions about who to handle or send things to, Brad Harris is here with us. He's been joining us. He is doing all the items for a real estate appraiser, and we're helping everywhere we can. So we will have an extra body there soon. But on your interview information, if you do have questions, Brad's been working with them, so we can definitely answer.
I just have a real quick.
Yes.
Are the pages numbered anywhere?
At the very bottom, if you
okay.
tap,
Very
yeah,
good. I got it.
you got it.
Thank you.
You are welcome.
Okay. Several that did not show up. Two that did not show up.
You got two, yes. Jason Stewart DeBusque and Christopher James. I'm going to even do worse on that last name.
All right, Rex, you want to tell us about yours?
Sure. I met with Trinell McLennan this morning. We met for about 45 minutes. We went over a few reports. We talked about several things in the report. After the interview, I want to pass her on to approve the upgrade to, believe she's going from a trainee to a certified residential.
Okay. All those in favor say aye.
Aye.
Any opposed? All right, thank you, Rex. Motion carries. Mr. Atwood?
No, I did not have one today.
Okay. So Roxanna Dylan Bird.
That is correct. Brad, was he missing something? Yes. Okay, so we are down to just one for this meeting.
Okay, very good, very good.
Thank you.
I was not notified of that one, by the way.
Mr. Dillon?
It was on last meeting's docket. He did not show then, but I was not notified I was supposed to be here today, so I wouldn't have been prepared for it anyway.
Had we gotten everything, we would have probably sent it to you last week, Thursday or
Okay.
Friday. We kept him on just in case.
Oh, it was
so
a
we
week
could load
ago.
this.
You didn't.
Yeah.
He didn't just show up today and didn't have anything. Okay, thank you.
Okay, moving on to.
Absolutely. So Dr. McCarr was not able to join us. I will go through his information you've got on your iPads. It's on page 18 and 19, his recommendations on all of those are to approve. And he is listing his course proposals as far as, we can go into the details on all of them, but he's basically listed it on the spreadsheet, if you want me to add anything else. He's got 29 course proposals for continuing education. One is for continuing education for qualified education. One is for QE only. 29 of the CE courses are including the CE and the qualified course, and the qualified education only courses are presented via the traditional classroom instruction. So he's laid out a little bit of his reviews. One of the CE courses was presented as an online course only, and what he's done on his recommendation is the two that he was in question of, we have pulled off the form, so you don't need to review it until he has a second chance to go through it all.
Have his letter in front of, each one of you has his letter in front of you. If you want to take just a minute and look over his letter. We're not getting a tremendous amount of education for qualifying, are we?
I haven't seen an increase or a change in it, so I think we're lower in that category.
Lower in what way?
As far as the numbers that are coming in
Coming
are
in?
mostly.
Yeah, most
the
of
continuing
it's
education.
already set.
Correct.
And, yeah.
Just the repeats.
We'll hear a motion in regards to the education hearing, education report.
Motion to approve.
Second.
Motion been made and second to approve Dr. McCara's education report. Any discussion? All those in favor say aye.
Aye.
Any opposed? Okay, education report carries. Thank you, Dr. McCara and Roxana. Legal report.
Let me start with, you were to have a hearing today. Oh, and someone has a question.
I have one question. Was the information on the back of Dr. McCara's letter in reference to anything
It
on
was
the
just
education
information
report?
on the instructors in case you needed it.
Gotcha. Thank you.
He was very thorough.
Go ahead, I'm sorry.
Okay, that's okay. Well, you were to have a hearing today. That hearing has been continued to July with the hope that the proposal I'm about to present to you will be acceptable. If it is indeed acceptable, then there will not be a hearing with me in July. The matters were a 2015-020881 and a 2016-042691 complaints. There were two complaints. The first one concerned violations of the standard rules, and the second one concerned a revocation of a temporary certificate in Mississippi. In the first complaint, the recommendation is for me, and I did speak with Roxana on this so that I'm not coming in blind, was a $2,000 civil penalty plus 20 hours of continuing education, some of it in appraisal writing.
How many hours?
20. This is what's been agreed on in appraisal report. Some of it have to be appraisal report writing. $2,000 civil penalty, payment for the reviewer of the $1,200. In the second case, it'll be a 3-month suspension beginning May 1st, a $500 civil penalty, and also to begin on May 1st, with the request that there are 6 months to complete the education in case you can't get it in based on what's being offered, and we did look at that beforehand. This is to me, it's a good compromise. This particular respondent has a very low appraisal number. It's been in the business a while. As you know, in any kind of litigation, there's always going to be the other side of the story. I'm also very confident in myself, and when it comes down to litigation, having said all that, I do think this is an appropriate response and an appropriate resolution to the two cases that were going to be in the one hearing. I didn't do this alone. I did meet with Roxana to make sure she was on page with all of this, and so I am recommending that as a proposed settlement. I don't want to go into the details of what the violations were more than that in case you don't agree on the surface, because that will could prejudice against him for the hearing in July. If you agree to these terms, then I will prepare what's called an agreed order, and I will send it to you, Mr. Thomas, via email for your signature, and then we will sign it as well. The agreed order will say it's a suspension. Should any term fail, of course, it's either a further suspension. So it's not like an absolute. You do have to follow the rules and the laws within the agreed order, or you're in trouble again.
Okay. Anyone have any questions?
Yes. Could you restate what you can tell us specifically?
Sure.
The two,
Yes.
the difference in the two
Complaints. In the first complaints, it was 2015. We had a reviewer go over it, and I will tell you that the initial reviewer is no longer hired, so we had to hire another one. And there were violations of Standard Rule 2, 2.1, 2.2, and Standard Rule 2.3, and Standard Rule 1.1.
Mr. Chairman,
Sure,
may I ask Mr. Attorney a question?
for $1,000.
All right, for $1,000?
Go ahead.
She finishes answering my question.
Oh, were you not finished? Okay, no, continue.
Just keep that in mind. Don't forget your voice.
Okay, do I need to repeat that?
No.
Okay, and in the second complaint, there was a temporary certificate in Mississippi that there were complications of, that was then had a hearing and it was revoked, and under your law, any revocation of the state could be suspension here, revocation, or there's a couple other things you can do, civil penalties. And so the recommendation, again, for the first one is a $2,000 civil penalty for violation of the rules spoken of, and then for the second one, a 3-month suspension plus a $500 civil penalty. In the first one, there will also be reimbursement of the appraisal's costs, which is $1,200. There will be 20 hours of continuing education, including appraisal writing, in that 20 hours.
Okay. Hold on a minute, Mr. Johnstone. Is that satisfying?
That's fine.
Okay,
yes.
okay. Mr. Johnstone.
Good, all right. Question, on the doctoring of the Mississippi license,
It wasn't doctoring.
well, it looked as if it had been whited out and typed in. Could you please explain how he or she responded to that?
The issue we have, more importantly than that, is that in the hearing that the testimony was that it was not doctoring, that if there was any problem at all, it was a problem in the copying between the machines. But I can't give you any more information than that, because the big issue for us in the end would have been at the hearing the fact that it was revoked, and that the problem, what the other court found is, regardless of all the details, is that the respondent was working prior to getting the absolute approval of the temporary certificate, and that was the issue.
So the revocation came from Mississippi. What was their basis for doing
That's what I
that?
just said, that he had been working in
Oh,
the
that
state
he'd been working,
without
not that he
getting
had
the-
tampered with
yeah.
the,
Yeah, not that he tampered with it.
no, he said he didn't tamper, but
He said it was a complication between the
it looks tampered when you just looked at it.
he,
But I understand. I appreciate that.
I have any more questions? I have a quick question. When you decided on the 20 hours, I don't really care about the money, but on the 20 hours, Roxanne, you correct me if I'm wrong, but it seemed to me like we had discussed before that we were going to do pretty much things in increments, not that it's going to make a big difference, we were going to do things in increments of 7, because that's the way courses are offered. Can you move this? Because it's not going to matter, because he's going to get 21, but he's only going to get credit for 20.
are you suggesting that I change it to 21 instead of 20?
No, I'm just asking, how, if there were specific courses where you said, okay, they're going to equal 20 hours?
No, there was a
Okay.
number that we looked at based
Okay.
on what might be available. We
Okay.
were looking
And that's
online.
fine, because he's going to wind up taking 21
Yeah.
hours, but he's going to get credit
Yeah.
for 20.
Right.
Okay, or she, or whoever.
Yeah.
Okay, I just wondered about
Yeah.
that.
And
And I
Okay.
think only to add to that is, this is a 2015 and 2016 case, so at that point, we might not have been
Okay.
looking at
Okay,
that as
very good.
specifically, as now we know it makes no sense to offer a number that's not going to be met.
Okay, sure, no problem.
I won't offer a number again.
Well, I mean, we just, classes are offered in courses, it's 7-hour
Yeah.
courses, so
Yeah,
it's,
I agree.
And they won't count as CE, correct?
No, it'll be in addition to
Right.
anything
Doesn't
required in the
matter.
license
right,
law.
okay. So in that case, it doesn't matter.
1 hour would have counted as a CE.
Yeah, 1 hour would. You're correct.
Go on,
We don't grant 1-hour courses, do we?
Probably not.
Okay. Any further discussion? So this is something we need to vote on.
You do.
Okay. Hearing the recommendation from legal counsel, do I hear a recommendation or a motion? Further discussion? I guess I have I have further discussion. Okay, I recognize you, Mr. Thomas. Thank you. Did we have other corrective measures laid out prior to this?
I'm not certain of the question. If you're asking me what the terms of the settlement that have been
No,
proposed,
no, I mean, I'm asking, had we done something prior where he came back and said, let's negotiate, like, I mean, did we say your fine is $8 million, and he said, no, 2,000?
yes, you are asking for terms of prior consent orders, and I can't do that. I can't tell you what those are.
Oh, okay.
That's prejudicial, and it's not something that can.
Even though we voted on it?
Because this is now in the terms of a litigation matter.
Okay.
So if we chose to reject this,
Then
we
we'll have
would
a trial.
find out what those were in June?
No, on your July meeting.
July meeting,
There will be a
excuse me,
trial
yeah.
in July.
Okay.
All right. What's the pleasure of the commission?
I can tell you that the differences between what is being proposed is not big. But I can't tell you the terms.
For or against?
Do you have other questions I can answer?
In your opinion, this is as close to as good as it gets?
Well, I can always get someone's license revoked, but am I confident that's the right decision, that wouldn't be appealed, that might not be challenged later on? No. Am I confident that this addresses the situation at hand? Yes. This is not if this were a brand new young appraiser, I'd be saying different things. But this is someone whose license is in the single digits, when not necessarily young, not necessarily old either.
You should have known better.
Well, this has also happened in 2015 and 2016. That's 2 years ago. And what we are suggesting is not dissimilar greatly to what was suggested in the first place, not greatly. As I said, I did consult before we talked any kind of terms with Roxana, and since she knows you all and historically how you've approached things.
Okay, and then to reference what you made a comment on previously, if we vote for this, he cannot back out of this.
No, he can't.
Okay, very good. All right.
I'll make the motion to accept council's recommendation.
All right, motion's been made to accept council's recommendation. Do I hear a second?
Second.
Motion's been made and second. Any further discussion?
One more question.
Sure.
What was the property type again on that?
It was a commercial property.
Commercial, okay.
And let me tell you that the initial complaint came in not related. I mean, the initial reason for the complaint is not anything you'd be reviewing or discussing.
Further discussion. We have a motion and a second on the floor to approve council's recommendation. All those in favor say aye. Aye. Any opposed?
Aye.
Okay, motion carries, but it's not unanimous. Thank you very much. Thank you.
No trial then in July unless one of us said something else.
Excuse me?
No trial then in July unless one of us sets something else.
Okay.
Just to assure you on that.
Just for a point of clarification, may I ask a question? Even now we've voted to pass this, can he turn this down?
No.
Okay.
This
That's all I
is
need.
negotiated between, if he turns it down, he has a hearing in July.
Okay, that's what I'm asking. So he can still turn it down?
Well, everybody can always do something like that before it's signed, but I have the assurance of his counsel that after much
Okay.
negotiation, that this is terms that have been agreed to.
Okay, great. Thank you very
Now,
much.
can something change? Sure, because people are people. And they sometimes tend to do that, as any criminal attorney will tell you, and I'm not a criminal attorney, or an attorney that practices criminal law either.
Very good. Thank you very much for all your time and effort.
Sure.
We appreciate it.
Now, to the legal report, and please refresh my memory. I haven't been with you all that long, so would you like me to read Yeah, good. That was the right answer. So, shall I read the numbers and then just stop for discussion?
Yes.
All right. Number 1, 2017-070811. Will tell you my recommendation in the summary for that. That there were, I'm summarizing now, that there were some minor violations of the standards and rules, and therefore my recommendation was for a letter of rewarding regarding SR 2.1B and SR 1.1C, as found by the reviewer.
Okay. You've all read number 1 and heard council's recommendation. Anyone want to make a motion or discuss this?
I have one question about the letter of warning. Do they get the comments from the reviewer, or is it just noting the standard rules?
I generally, in the letter itself, I'll say what the reviewer said.
Okay.
Okay, I generally do that. So
Right.
it's not quite as detailed, but I'll say the reviewer found this, the reviewer found that,
So-
and there's a
so
letter
they're
of warning
getting
saying-
some instruction.
Yeah, so it's not
Right.
just a naked
Right.
letter.
Yeah.
I would question the conclusion that these are minor errors and omissions. That is stated, but then there are other indications of things that are not minor. Specifically, market conditions adjustment was not supported, a trend was not supported. There's no, evidently this is a mountain, as a property that's a strong degree of the value is in the view, on mountaintop view. That was not adequately, as I understand the reviewer's comments, that was not adequately described in the report, and probably then not given adequate valuation considerations, contribution of the view. Other things are stated in the reviewer's report that adjustments maybe were not supported, or the cost approach was not supported properly. And this is a second violation of this individual. Disciplinary history. They already have a $1,000 civil penalty against them in a previous thing. I would suggest for consideration, or at least comment from the commission, that a letter of warning here is not sufficient.
May I just say that this was presented, just so you know, the question from the complainant was an ethics violation, and whether or not there were any ethical violations by this particular respondent. So we had it reviewed, and the conclusion was, as you say, that it's objection and impartial value opinion, and that there were lacking, but specifically what the reviewer found is exactly what I said. Supporting data explanation and analysis applied or lacking, and that there were inconsistencies and minor clerical errors and omission, and those were the summation of what the reviewer found, based on everything you read into the record.
The reviewer states two specific violations at the very bottom there. SR 2-1B, reviewer states supporting data explanation and analysis applied are lacking. That is not minor, in my opinion. That is not a minor violation. If they don't support their data, their explanations, their analysis, their conclusions, that is, especially when this is a second violation. So I'll make a recommendation, but I'll open the floor, let somebody else speak if they would like to before I do that.
Anybody have any comments on Mr. Atwood's statements? Any further discussion on this case? Mr. Atwood, do you wish to proceed?
I would like to make a motion that the I would like to make a motion that we that we require this individual to take 15 hours, whatever, 14 hours of report writing as a minimum.
All right, motion's been made to recommend 14 hours of report writing. Do I hear a second?
Second.
Motion been made and second to have this individual take 14 hours of report writing. Any further discussion? We're going to vote on Mr. Atwood's motion to add 14 hours of report writing onto this case. All those in favor, say aye. Aye. Any opposed? Motion carries to add 14 hours of report writing to this. Thank you.
Just so you know, it'll be in terms, in form of a consent order for violations of the rules and outlining what was suggested as being the violations for 14 hours of report writing.
Thank you very much. Before we go, Roxana, where is it where we can use those corrective education courses? And do we have a list of those?
I don't think they're on our approved
What
list.
corrective courses?
It's an AQB corrective course that they.
Yeah, that was presented, not last October at Arrow, but the one before, I believe. I would steer against that because there's only one provider for those corrective courses, and I think we need to be careful about recommending a specific course to one provider.
Good enough for me. I just wanted to know what the, instead of doing all this, I wanted to know what the name or what the course is outlined. Yes, ma'am.
And before we would do that, I would kind of want one of you all and maybe myself to go set through that course just to make sure.
That's what I asked the other day, if we could
Yeah.
sit through those courses, because I thought it'd be nice if the
And
whole
because
board.
they have said we could, I
Yeah,
think that we
right.
need to.
Okay.
We need to do that just
Yeah,
so.
All right,
my one concern, that wasn't opened up to multiple providers, so now you're instructing someone to take a corrective course to a for-profit organization, and I think we ought to be careful with that.
Yeah. Okay. All right, proceed with legal.
Number 2, 2017-071891. This complaint was opened and it was sent to a reviewer. The reviewer's conclusions are outlined in your report, but the reviewer did say the final opinion of value is adequately supported, but there's a potential deficiency regarding Standard 1 and Standard 2. Standard 1-4, given information submitted may not have been properly developed, it does not sufficiently meet USPAP, and the review of the cost approach indicated reliable cost sources and methodology were employed, but an opinion of site value was reported with no summary information and no appropriately detailed discussion of the highest and best. My recommendation was a letter of warning regarding SR1 and SR2 and using the cost approach.
All right, you've heard council's recommendation. Any discussion? Anyone wish to make a motion?
I move we accept council recommendation.
All right, motion been made to accept. Do I hear a second?
Second.
Motion been made and second to take council's recommendation on case number 2. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries.
Number 3, 2017-072061. After this complaint was opened, it was also sent to a reviewer, and the conclusion of the reviewer were that the appraisal report and supporting documentations were credible and professionally executed, and that the major complaint was that appraiser reported the property as vacant on inspection, but reviewer states that based on review report and supporting documentation, reviewer could have come to the same conclusion. Therefore, my recommendation is to dismiss.
Any discussion on this, number 3?
Move we accept the recommendation to dismiss.
Second.
Motion been made and second to dismiss number 3. All those, any further discussion? All those in favor say aye.
Aye.
Any opposed? Number 3 carries. Thank you. Number 4.
2017-072451. This was also sent for review, and the reviewer's conclusions were that there were violations of SR21, that some items in that were noted as average in condition when in fact the items were new, and states that the appraiser must not mislead it, and appraisal must set forth in a manner not misleading. SR1-4, SR1-1BC, SR2-257, 8, In the sales comparison section, some of the data and the comparables is incorrect, and an appraiser is supposed to verify all information and cannot commit or should not commit substantial error. SR1 2-1B and SR 2-2A 8 cost approach did not have information to support appraisers' opinions and conclusions. Therefore, my recommendation was a $1,000 civil penalty for violations of the standard rules as found by the reviewer.
You've heard council's recommendation on number 4. Any discussion?
I would comment that a civil penalty is, to me, not appropriate in this case, maybe education, but a civil penalty, I would not go
I would
for, since
agree.
this is our first offense.
That in the form of a motion to remove the civil penalty?
Well, I would make the motion to remove the civil penalty.
Motion been made to remove the $1,000. Do I hear a second?
Second.
Okay, I hear a second to remove the $1,000. We're going to vote on just removing a $1,000 civil penalty at this time. Or any further discussion on that? All those in favor of removing the $1,000 civil penalty on number 4 say aye.
Aye.
Any opposed? All right, the removal of the $1,000 civil penalty on number 4 carries. Mr. Atwood, do you want to suggest courses on this, sir?
I'll ponder a moment if someone else has a thought.
Rex?
I was going to throw out a 7-hour sales comparison and 7 hours cost.
Okay. Any discussion on the 7 hours sales comparison, 7 hours cost? Would you care to put that in?
So moved.
All right, motion's been made that we add 7-hour cost approach and a 7-hour, what was the other one? Sales comparison approach. 2 courses, 7 hours each to this.
Second.
And seconded. Any further discussion on the addition of these 2 courses? All right, we're going to vote on adding 7-hour cost, 7-hour sales comparison to this. All those in favor say aye.
Aye.
Any opposed? Okay, we're removing the $1,000 penalty and adding the 2 classes to number 4.
Number 5, go ahead.
Just to make sure my notes are clear, so really in number 4, we're just not going with the recommendation. The new proposal is 14 hours of courses, 7 of which are in sales comparison and 7 in cost.
Correct.
All right, thank you.
Number 5, 2017-076501. This also was sent for a reviewer, and the reviewer states respondent submitted 2 appraisals with the second appraisal dated the same date as the first. The reviewer also found various violations of the standard rules, including 1-1B, 1-2E, 1-2H, 1-4F, 2-1A, 2-23. Because of the number of violations found by the reviewer, my recommendation was a civil penalty for $2,000 for the violations of the rules that I have stated.
Okay, you've heard council's recommendation. I'll open it up for discussion.
I've got a lot of questions on this one. I had a hard time following because it was hard to figure out what the issues are. For starters, it starts going in about the scope of the assignment, that the scope was expanded. I'm more curious what the scope was expanded to and what didn't they meet in that. Also, it goes on and on about sewer not being noted. How did that play into the final value and the highest and best use? There wasn't much given here as far as how that played into the highest and best use. Was it a development track and they could develop more lots if it had sewer? What was the issue with sewer and how did it impact value? Or was it just something that was checked and shouldn't have been checked?
Yeah, I think it was something that was checked and should not have been checked, and it could have affected the value in the end because the presumption then was the sewer was available, and it was not.
But was there an adjustment made? Was the analysis coming down, and did that impact the final value? Did he
Could have been a
use
clerical
sales?
error.
Yeah, yeah. Did the analysis support not having sewer, but it was just checked that there was sewer? Did he make an adjustment for some sales that didn't have sewer?
No, I don't think so. I think the issue of the sewer was important to what this property was going to be appraised for.
That's going back to the highest and best use issue. What is the highest and best use of this property for a subdivision that sewer was an issue, that they could do a greater density of lots? Because there were so many questions with this one, I couldn't decide if I'm in or out. I had some questions with reviewer comments. He states that 2 reports were given. He said second report would have been better to state the respondent had previously appraised and a new appraisal was prepared. That's not correct. We're not required to do that. It's still one assignment. So he doesn't have, if he's making corrections, he doesn't need to state he appraised a property before because it's all the one assignment. So that was a concern I had from a reviewer standpoint. But in essence, we're rolling down and then getting over to the TDOT issue, and it's noted as standards rule 1-4F, and it goes back to what was the scope of the assignment? Was it a point in time appraisal? Was it for eminent domain? How does this play into the final value as it was presented?
Well, of course, I don't think I can answer that as not being a
Yeah, well,
professional.
that's what
I can
there's just so much
I
here
understand.
that is questioned, and then to come down with a $2,000 civil penalty, I just don't have enough information to say they screwed up or not, because I don't know what the scope of the assignment was and how the sewer issue played into it.
Well, I think I reported everything that the reviewer found and reported.
Yeah.
I can tell you that the original complaint was that the owner was not correct, the acreage was not correct, the photograph was not part of it, and there were no definitive addresses for the 2 comparables, and that's what the original complaint was about. And that the respondent then said, well, the owner had the name was from the tax records,
Right. And sometimes we're limited on
and I understand
the information
that.
we're given.
But so all of mine came from what the reviewer found as problems with both reports. The reviewer looked at both of them and
Right.
came to these conclusions.
Yeah, and my questions for the reviewer, when he makes that comment about noting that he appraised it before, now I start to question the reviewer.
I understand.
Can I ask, we don't have any idea who the complainant is, as far as a homeowner or a
The
lender?
complainant was the property owner,
Was a property owner,
the property owner of
the
this
property owner. Okay.
And the scope really plays into this. You know, what was the problem the appraiser was trying to solve? And what didn't he do that the property owner wanted to see?
Well, and I understand that, and again, I can
But I don't
only
know beans about
make my
it.
summations
Yeah.
from what somebody
Yeah.
professional overlooking it
Yeah.
tells me.
Yeah,
Because I have what was presented, and then I have the original appraiser's response to the complaint, and that's what I have. And then after that, it requires someone to look at it and say yay or nay on it, and
Sure.
I am relying on them. It doesn't mean they're going to be correct, and you're certainly welcome to disagree with them, and absolutely you are. You do not have to take my recommendations ever.
I'm curious if anybody else read this and was sort of confused and
Yes. I would like to say that I'm somewhat disappointed in many of these review responses. Can I ask the question, are these new reviewers?
I don't know.
Do you mean brand new to?
Reviewing
doing-
for the state, for these complaints, do they, understand, are they experienced state reviewers?
They are experienced state reviewers, and
They've
you all
reviewed
know
before.
from me reaching out to you that we've run into a situation of
I knew
of
that.
a shortage. So we have put out a contract again, and we think we're balanced now, but we don't have brand-new reviewers that have never done it before, if that's the question. Now, what we can do on this complaint or any other, as Robin said, we don't have to go with this recommendation. Specifically, if the review is not sufficient enough for us to make a determination, we can ask for specifics and send it to a different reviewer. As Sarah in a minute will kind of explain our hopes of having some flexibility with the reviews moving forward, then hopefully we can send it to somebody else that we've got a contract and have them look at specific things that you have questions about.
I guess the thing that bumfuzzles me, I guess, the most is this individual, male or female, has had their license since 1993. They've never had a complaint filed against them, and all of a sudden they got this appraisal that they've totally screwed up. So, I mean, I just got, I think I'm like Rex. There's so much here that points in 18 different directions that I'm confused on it.
It states in here the acreage was incorrect. Was it multiple parcels? Was it one parcel? I mean, there's so many variables that are going into this.
Yes, I'd have to,
Yeah.
you have got what I've got from it. I don't have more specifics
Can
than
I
that.
throw out an idea? Mm-hmm. We have this reviewed again and give specific things that we're looking for from the reviewer, such as the scope of the assignment. How didn't the appraiser meet the scope of the assignment? And was it well communicated? How did the sewer issue relate to the highest and best use? And did it have an impact on value?
We have a recommendation from Mr. Garrison.
Is there anything else, y'all?
Do we need to ask them to comment on compliance with TDOT? That was brought into the
Yeah,
thing.
yeah.
Is there a
That-
compliance with TDOT requirements?
That seemed to come from
Tennessee Department of Transportation.
1-4F. Yeah. So we're going to make a recommendation to postpone this.
Let me read back the notes that I took, that way we can make sure to get it right. So it's my understanding, and Robin will correct me if I'm wrong, that we're not going to go with the recommendation. Instead, we are going to ask for a second review. But the second review would go to a different reviewer, so that we have somebody completely new coming into it with specifics of what we want answered for the next time it's presented. Among the things to be answered is the scope of the assignment. How did he or she not meet that scope? Was this expectation communicated to the respondent? The sewer issue, and what role does it play relative to the highest and best use of the appraisal? Did it have any impact on the value then assessed? And was this or was it not in compliance with TDOT? What was the issue with TDOT?
All right.
And I need to add one thing to that for clarification. The, under the scope
Yes.
question or component, have the reviewer compare that scope of the assignment section with the engagement letter and instructions from the client to make sure those are consistent.
All right, I would like to entertain a motion in regards to the recommendation so that we can vote it up or down. So the recommendation is $2,000 civil penalty for the violations. Do I hear any recommendation on that?
I think
I
you're
would move that
amending
we
it
ta-
all together.
I think I would move that we table
Okay.
that recommendation until we get further clarification from the second reviewer.
That's fine. Okay. We're just going to table
Well, what
this,
will happen-
table number 5.
No, what will happen is that you have agreed to have this reviewed again, and so I am putting it back on your docket for review in July,
Okay, thank you.
after it has been reviewed with the component you suggested.
Okay, very good. Thank you.
Mr. Johnston, if I could make sure, on the scope of assignment, you've got us adding that you want the new reviewer to compare the assignment section with the instructions and what the client signed for.
Because part of the reviewer's comments were that the client ordered a market value appraisal included other requirements that were not addressed in the appraisal. So a lot of times the clients will have specific things, and that could be relevant to the scope, and if the reviewer is new or not or seasoned, sometimes I review a lot of reports, and it never fails. I can go, first thing I do before I even review one is go to the engagement letter from the client and read that, because inevitably there's always things left out.
Thank you.
All righty. Number 6.
2017-077321. In this particular matter, the complainant was a property owner and stated that the appraisal came in $20,000 under contract because the respondent missed 200 square feet and did not actually measure the home. The respondent says that respondent has been used the same vinyl measuring tape for 19 years, but invested in a laser one for interior parameters. The reviewer found numerous issues with this particular property appraisal. They found problems with the neighborhood boundary description, the site data, building and improvement description, the sales comparison approach, the reconciliation and conclusion, and specifically found violations of SR Rule 1-1, B, 1-1C, SR2, SR2-1A, SR2-8. My recommendation for these violations was a $4,000 civil penalty, a 7-hour continuing education class, and appraiser, USPAP, and review errors.
All right.
That was for number 7. Did we skip 6?
This is 6.
That is 6.
That is 6.
6 has a recommendation of a letter of warning.
No.
Oh,
No,
Mine says letter
That's
of
what mine
warning.
has.
I don't know.
you got it wrong, you got the wrong list.
This is what was sent to us.
Mine's 2017076901.
Number 6 is 2017-077321.
Yeah, that's
Not what I
that's
have.
number 7. And
I
the
believe
what
number
I-
6 was initially removed by
Yes.
another attorney,
Yes.
and so you got an amended legal report.
Look on your iPad. One got taken off, so it's probably altering your
Yeah,
number. The
my
last one got
paper's
taken
what
off
I
your
made
pa- your
notes on
page.
and
Yes,
read.
I know.
Okay.
But it'll make
we will
sense.
get
Nothing
it
was
later
changed.
here.
Yes.
Next
later.
month.
Oh,
Yes.
next month?
Yes,
It's
that one is
not-
removed.
Okay.
The one that you're speaking of is removed. Another attorney has a parallel manner with case
Okay.
with that, so it's being presented next. I mean,
Okay.
your next meeting. Sorry.
We're discussing the one that the last 5 are 77321.
That's correct.
Okay.
Very good. Okay.
I have a question. You said that the appraiser stated that he was using the same tape measure for the last 15 years?
19.
19 years?
Yes,
Yeah.
The dates don't, was,
I understand. That's the information that was presented from the.
Now, he's been licensed with us since 2015, but it could be that he was licensed somewhere else and has had. Is that the concern with the dates?
I was just
No.
confused by
Yeah.
that.
Yeah.
I have, Mr. Chair, I have several questions regarding the competency of the reviewer.
Okay.
Number 1, what is the reviewer's competency to know what the boundary description, whether it's accurate or not? Is the reviewer geographically competent to state whether the boundaries stated in the report are accurate or not? But even more so, on the sales comparison approach comments, the reviewer states that the size of the living area is incorrect. I would like to know how he knows that, or she knows that. Did they go measure the house themselves? Where did they come up with the correct living area for the subject property? And so those are questions that I don't, again, these are reviewer questions that should be more clear.
Well, the reviewer does state that the 1482 square footage was error because the recent measurement of the structure indicated an actual square footage of 1586.
Who measured it for the 1586?
It appears that the response, I can't tell you who did it. The error, this is something that the reviewer found. I
Oh,
can't tell you
yeah.
exactly who. I'd have to go back and look. Would you like me to look?
Well, yeah, and I agree with Jim. You know, that's only 102 square feet difference,
But on the front, they state 200.
but there's 200.
In what standard did they use for
The
measurement?
200 is what the
Exactly,
complainant
yeah.
said was
Yeah.
the difference.
Right.
Okay.
And that's the crux of this whole case, because there's several standard rule but it all comes back to that they misrepresented the size.
And the square footage for the lot, also the site itself?
And that was 200 square feet, and
There was
it's
a
not
problem
much
with that.
difference.
Well, I know that, but what I'm saying is there were two differences. One in the size of the building, and one in the size of the lot. Those were the two problems the reviewer found.
Having significant problems with the reviewers.
Yeah, I would agree.
And an irregular rectangle, unless they've got that's kind of,
For people who aren't aware, 100 square feet and 200 square feet is a small difference. Most of the time, 100 square feet isn't even adjusted for when you're doing the appraisal.
And 200 square feet in a lot size means absolutely, because where I live, we don't base lots on square footage. It's half acre or 3/4 of an acre, so.
These are errors that the reviewer found,
Right.
and based on the errors the reviewer found, if the recommendation is
Sure.
mine, you should understand, not the reviewer, it's mine.
Sure.
So my
Okay.
question is, how did the reviewer verify these measurements?
I'm not sure the question. Are you asking if the reviewer went out and measured?
Yeah,
The
the reviewer states that the living area is incorrect. How does the reviewer know that?
I understand. I'm sorry, I don't put everything they review.
Oh, I'm not opposed to you. I'm
Yeah,
opposed to the reviewer.
Well, I understand, but I know that they do review all the documents that are presented to them, and they do their independent review as well. They generally do not go, and they don't state they do, to go to the property to do the review unless we ask them to do that. They generally don't do that.
there has to be a basis for them stating that the size is different. If they use tax records, then they need to say, I use tax records. If they used MLS, they need to say, I used MLS. Because those are.
But they did use a public record survey on the, they did say that. The information that was listed was with the correct size of the property itself was from a public record. That was what was used for that. And that what the reviewer is suggesting is that the difference in the square footage in the building itself was that the respondent used a tax sketch and didn't complete a measurement of the structure. And I can tell you that. I can't tell you that they're.
You're not required by USPAP to measure it.
I know,
What you are required is to state where you got it. So if he said he measured and he used a tax card, then there may be an issue. But,
Implied. The person implied they measured it. I
Right.
can't tell you they did or didn't.
right.
I mean, that is the
yeah.
original, the
Yeah.
respondent.
Yeah.
I don't see how the reviewer would know that, though,
Yeah.
because how would he know, or she know, that the difference is 200 square feet? They had to have a source. I just,
It had, yes, and it was from a recent measurement of the structure on a record that this reviewer looked at. I'm sorry.
I guess my question is, if the homeowner measured it, we already know they missed it by 200 square feet earlier. So who measured it, and by what standard was that measurement taken?
You mean the original measurement? Are you talking
No,
about
I'm-
the subsequent
well,
measurement?
The one that, nobody knows the answer to these questions. That's all I was trying to say.
Okay.
I mean, I know you-
There's
and I
another
don't-
statement here that's puzzling.
Go ahead.
Under reconciliation and conclusion, reviewer states size is not correct, and then the next statement, the report that relies only on sales comparison approach is not credible. That is not a true statement.
Would you like to have this one reviewed by another person as well? And if you would, what were the questions you'd like to have that reviewer look at?
And two, I'm going to go out on a limb here. I would also check to see if those two were reviewed by the same reviewer.
I don't believe they were.
Okay. I would just
Okay. I don't
think and
believe they
check.
were.
I would almost be willing to dismiss this one.
Yeah.
Anybody
Fine
have a
with me, I
thought?
don't have to draft a consent order then.
Is that in the form of a motion, sir?
I'd make the motion to dismiss this complaint.
I second.
Motion's been made. You guys could have saved a lot of time. Motion's been made and second that we dismiss case number, the last five numbers are 77321. It shows up as number 6 on mine. All those any further discussion? All those in favor, please say aye.
Aye.
Any opposed? All right, motion carries. We dismiss number 6.
Before we go to the next one, go ahead, I'm sorry.
No, you go ahead, because I am going to interrupt us.
I just
before
need
we
to go on the record that these reviews are not very good.
I've made note, and I will look at both of these reviews. I don't know that I have a great solution. We may have at the next meeting a different proposal on how we want to have things reviewed.
Here's some thoughts. Maybe from the reviewer, maybe we need to come up with some kind of guidelines of what we're looking for. And that way would you agree, Jim? You know, some guidelines and get some consistencies on the reviews. And 2, we might even, here in a couple weeks at Arrow, sort of talk to some other states about what they're doing, what they're getting on their reviews, so we can get some consistencies. And it helps the reviewer if they know what the scope of the assignment is and what the question we're asking them for in the review.
I don't think in the past, at least, they've been given any guidance because the cases vary so much. So I think our approach is, here's the complaint, and based on the complaint, figure out what you need to look at. And as you all know, we've had to kind of beg for the 4 we have now. So I think at the conference, asking, other states are seeing this. There's no doubt in having the same type of problems. Maybe not to the extent we are. But on this one specifically, it's the commission's decision to dismiss it, and I trust you wholeheartedly. I guess I'm just a little concerned if we had such a high civil penalty and so many violations and hours.
The violations are for the same thing.
Okay.
It looks worse on paper than it really is.
I have another question, and you may not have an answer for me. What did VA say about the appraisal? Did they take the appraisal? I mean, this looks like it's just so bad. You know, they would have just shot the guy or something.
I can't answer that
Okay,
question.
I didn't think we could, but I'm just thinking this is a VA appraisal.
Well, it said the sale fell through, so who knows if they even saw it.
Oh, well, okay. You're correct, okay. All right, moving on to what I have is number 7.
2017-077281. This matter was reviewed, and the reviewer states after reviewing the file, the reviewer saw no reason to work up a USPAP compliance review when complainant did not identify the property or any issues with the appraisal report. Therefore, the recommendation is to dismiss.
Any discussion on number 7? You've heard council's recommendation to dismiss. Do I hear a motion?
Move to dismiss.
Second.
Motion's been made and second to dismiss number 7. All those in favor say aye.
Aye.
Any opposed? Number 8.
2017-078381. In this case, the complainant works for the company that hired the respondent to do an appraisal on property. As part of the quality assurance process, respondent was asked to provide clarification of several matters. This also said that the complaint was in violation of the ethics rule. Complaint included the screenshot of messages. Complainant states respondent was notified of this and given an opportunity to respond, but did not. A reviewer did review this and states that the report is generally complete, but notes that the contract section is lacking a detailed analysis of the contract and notes other issues. In particular, the reviewer found that there were some canned statements with very little information in the neighborhood review, but for the most part, that the reviewer states that there was, is concerning the ethics violation. The reviewer states concerning the text. The reviewer states the statement in the first shot is rather vague. It's so vague it's difficult to say it's any kind of USPAP violation, and that it should be proved that the respondent made the statement, which is not clear from the vague screenshot. And the second statement that was included in the complaint, the statement does not disclose anything except the report had been completed and that the report was justified and there were no violations or disclosure. And in the reviewer's opinion, there was then no USPAP violation. Although the canned statements were for, the issues were in the cost approach, some minor issues, the cost approach, the neighborhood, and the sales comparison. So therefore, my recommendation was a letter of warning concerning the violation of SR 1-2E1I, SR 2-1B, and SR 2-2A8.
All right, you've heard council's recommendation on number 8. Any discussion from the commission?
I do not see anything here. Canned statements, if we discipline canned statements, we would be disciplining every appraiser in the state. I don't like canned statements. They're not right, but they're not something to merit discipline. I move we dismiss.
Second.
Motion's been made and second to dismiss. Do we have any discussion? Yes, we do. I just have a question. Is that the way I read this, when the complaint is first filed, are they saying there's an ethics violation because the guy didn't return phone calls or texts?
Saying the ethics violation is because of the 2 text messages I was talking about
Yes, ma'am.
earlier, that somehow they are in violation because they were reported to somebody besides the person hiring for the appraisal. And
I see now. Okay.
And the reviewers basically said, first of all, I can't even say that they're from this person, and second of
Sure.
all, there's nothing reviewed or
Okay.
revealed.
All right. Motion's been made, excuse me. Motion's been made and second. Any further discussion on number 8? All right, we're going to vote to dismiss number 8. All those in favor say aye.
Aye.
Any opposed? We'll dismiss number 8. Number 9, please.
2018-007151, the complainant was a homeowner and had issues with the appraisal. It was sent for review, and the reviewer's conclusion was that did not find any violation of standard rules or other violations after review, and therefore the recommendation for me is to dismiss.
Okay. Is that number 9?
That is.
Okay. Any discussion? Do you have discussion, Gary?
I was going to make a motion to approve council's recommendation.
Okay. Motion's been made to approve dismissal. Do I hear a second?
Second.
Motion's been made and second. Any further discussion on number 9? Vote on number 9. All those in favor say aye.
Aye.
Any opposed? Number 9 is dismissed. Number 10.
2018-018-071, complainant said the respondent appraised a home the complainant had for sale and that calculated the home as 47 square feet smaller than actual size. Respondent states respondent physically measured the property and believes measurement to be correct. In any event, the complainant later asked that this be withdrawn, and based on all of this, therefore, I ask that it be dismissed.
Heard council's recommendation on number 10 to dismiss. Any discussion?
Move to dismiss.
Motion's been made to dismiss.
Second.
I have a motion and a second. Any further discussion? All those in favor of dismissing number 10 say aye.
Aye.
Any opposed? Thank you very much. Number 11.
I believe this is the last one. Did you have something to say? Okay, 2018-002951. In this particular matter, the complainant was a homeowner and the respondent was hired by the lending company for refinancing. The review was done by a reviewer, and there were 2 reports original, and the second review found some violations or some potential violations concerning rules SR 1-1 A, B, and C, SR 1-4, and SR 2-A8. A reconciliation reviewer does state that reconciliation addresses the applicability and suitability approaches used, but that states that a number of the comparable sales available made the sales comparison approach the most appropriate method. Cost approach was not used. And it came to the conclusion that the statements provide a minimum reporting analysis, support opinions, and conclusions. And therefore, my recommendation was just simply a letter of warning concerning the violations that were found in this matter.
All right. On number 11, you all heard council's recommendation. Any discussion? Do I hear a motion? All need clarification, or what are we doing here? A moment. A moment, okay. I suppose I have a real question with the whole group of complaints. and that is, it seems like this guy, or like this individual, has had his license since 1991 and had no disciplinary action. A while ago, there was one that was 1993 and no disciplinary action. Another one that was like 1992 with no Are us old guys just slipping, or what's the deal here? Hey, watch it. You're being recorded, so you need to be nice. You need to be nice. It's just amazing to me that all of a sudden, these are people who had their license for a while, and all of a sudden.
Do you know that, let me just say this, and you can ask Sarah for part of this. I think a lot of this has to do with the market in general, and therefore complaints come in more often because of the way the market is, and it goes up and down. So I think you're seeing a lot of this based on that. Not necessarily that people are doing worse things. It's just that people are complaining more.
Picking on the old guys. It's okay, I understand.
I guess with that, a question I have is on the complaint, are the complaints reviewed for their, if they're really warranted? If they're saying it just didn't appraise and there's no basis.
Well, let me explain. Unfortunately, the complaint process is that they are opened by our complaint review. What's the group called? Centralized complaints.
Right. So they open every program, not
And
just
once a
yours.
complaint is open, it has to be reviewed. So we do the reviewing, and once a complaint is open, also is sent to the respondent so we can get two sides of the story, always. Sometimes we don't get the second side of the story, but that is what we ask for. If it has been the practice, and this is why there are so many reviewers on this, it's been the practice that if there are specific complaints about the appraisal report itself, because I am not competent to tell you when it is, I can just tell you when someone else says it is, we send it to a third party who does then the review of the matter to make a determination if they find violations based on the complaint and the answer and the reports as presented. So yes, we do get complaints that probably are not warranted, and not just in this program, in all programs we get that. So, but they are presented and reviewed regardless.
But I think at that point, that it would be up to the commission to dismiss it. And then the history remains clean, and we know that that's the case. Whereas it could be that in the past, when it wasn't a centralized complaint process, and I know that for a fact, that things might have been able to kind of, if it's not in our jurisdiction, the statute doesn't let us do it, we might have, and I wouldn't have been in the program, but we might have not opened it because it wasn't in our jurisdiction. Now we really do want to open everything just to see if there's a pattern, things that we would need to look at. That's the only way to know.
And again, the complaints are up because the market is different. So just, that already.
Recommend to dismiss.
Okay.
Second.
All right, on number 11, recommendation is to dismiss. Motion's been made and second. Any further discussion?
Yes, please.
Mr. Atwood?
The reviewer in this one seems to be better than the other ones. And
Glad to hear that.
there are comments, several comments made by the reviewer that say that the appraiser did not support their conclusions. Supporting conclusions is vital, in my opinion, to a proper appraisal analysis. So therefore, I will probably be voting against the motion to dismiss on the basis that I think it's more serious than that.
Thank you, sir. Any further discussion? All right, number 11, motion's been made and second to dismiss. All those in favor say aye.
Aye.
Any opposed?
Aye.
All right, motion carries but is not unanimous. We don't have a number 12.
No, we
No,
don't.
ma'am. Okay, thank you very much. Appreciate all your hard work.
I will have the one that we will get that drafted. I will make sure that I cover everything as
Was
has
there
been
one
requested.
that we had an interview or something? I guess it was in the one I have, the hard copy, the number
Ms. Smith.
13. Yeah.
Ms. Smith was
It'll be
handling that.
presented next month. What they've
Okay.
decided is just to pull it with the next case that
Okay.
it was traveling with. So, yeah, so you all have what we had at that moment, and since then, they decided to pull it. I apologize for that.
All right.
Any other questions? Thank
No,
you,
ma'am. Thank you
gentlemen.
very much. All right, before we move on to proposed rules by the AQB, let's take about a 10-minute break real quick. let our coffee do its thing.
Coffee left, you better get it.
All right, we're going back on the record. Excuse me.
Mouthful.
Going to discuss the proposed rules from the AQB standards and a fee reduction.
Yep, and I think you skipped over one part, the legislative updates.
Oh, I'm sorry. I did.
Two bills that possibly affect us. The first one is House Bill 2248, Senate Bill 2465. It's called the Fresh Start Act. It essentially says that Regulatory Boards Division, we cannot deny someone's application for any felony conviction. It has to be a felony that is related to the profession. Our statute does currently say we are allowed to deny for any felony, but if you all were to deny based on a felony, it would need to come before you as a commission, and there's certain factors that are laid out in that bill that we would need to discuss before we denied it. Right now, I know with Roxana, when they review them, they don't deny for just any felony. They typically make sure it's, related, and then it comes before the commission anyway. So that's one bill.
I appreciate that one, Bill, but let me ask you just a quick question. Could you give me an example of a felony related to an appraiser?
I can. We had one several, not in a prior application. It may have come up in a renewal. But this was a gentleman, or I don't call him a gentleman. This individual was keeping children in a cage down in Florida, and no, he was an appraiser, a licensed appraiser, and if I remember right, we could remove his license because he was a felon in another state, and I think he was actually originally licensed in Tennessee and then moved to
But
Florida.
and I'm totally against, let me put that on the record, keeping kids in a cage.
I'm just saying what
Although I've
happened.
got this neighbor. But I'm saying, what does that have to do with appraisal business?
Typically, we're looking at felonies related to burglary, trespassing, aggravated assault.
And that's related to appraisal? I mean, the
Well, no,
aggravated
related
assault-
to appraisal would be fraud, something like that.
So are you saying if a
We look
guy
at
has
anything
committed,
where
if an individual's
someone is-
committed murder, we're allowed to give him we're not allowed to hold that against him?
Well, I think you can make the argument in any situation that if someone's a murderer, it's related to that profession because they're around individuals. And a lot of times what we look at for specifically for home inspectors or real estate agents, we relate it to if they're in the home at all, like what could put the public at harm with that individual. So we're looking at the harm to the public. Theft, burglary.
Someone on a sex offenders list.
Yeah, that's the kind of stuff we're looking at. If they had, a drug possession that was a felony charge, 20 years ago, that's not something that we're going to deny their application for. Things of that nature. So.
Okay, move on to the second part, please. Thank you.
The major part with that one is that there are a list of factors that were in that bill, and I can send it to all of you, that we would, if we were at that position where we were going to deny an application based on a felony, we would want you all to talk through those factors.
But on an application, there's a space that says.
Have you been convicted of a
Right,
felony?
okay.
So, the second one is House Bill 2537, Senate Bill 2458. I will tell you that I believe this was discussed in front of the House on Thursday, and I believe it passed, but I don't know what amendment passed, so I need to double check that. But the latest amendment that passed in the Senate would not apply to us. It outlines, it's called the Apprenticeship Act, and it's essentially that they believe all regulatory programs should have some type of apprenticeship in order to get into the profession. We're excluded from that because we have a trainee program. So under that latest amendment, it kind of lays out that we would not be required to add an apprenticeship program to our statutes because we have the trainee. So.
That all under legislative update?
That is all.
Okay, let's move on now to the proposed AQB standards.
Okay, this is the proposed rule packet. Roxana may be able to tell us what page it's.
You're on page 45.
And this is a big rule packet, I will tell you all, and I'm sorry it is so large, but Roxana and I decided that if we were going to do some rules to put them all together, the first part of this is, so I think we'll take it piece by piece. The first part is the course versus classroom for qualifying education and continuing education. Basically what I did is, if you look at, I'm trying to find the easiest rule to let you know. If you look at Rule 1255.01.05, I believe it's on page 3 of the rules, you will notice that we deleted anywhere in the rule that it says classroom and changed that to courses. And then we also put a phrase that says no more than 50% can be taken via internet or distance education. So this would be allowing individuals to take qualifying education or continuing education online. No more than 50% of their education can be online, though. So that is open for discussion for you all. I know we had talked about allowing some online. Roxanne and I just went with 50%. If you all don't want 50%, you just need to let us know at this point. But we thought that was kind of a fair trade-off, was half and half.
Does that fall in line with AQB?
We talked to
Jenny.
Tidwell, who is our audit person, and she said this was, she thought it was a very positive direction to go, and it would be okay.
And I'm correct in saying many states that touch and or border Tennessee allow 100%. Or several.
There were other states that we
I know
looked at that allow
North Carolina,
100.
you can get it all online.
Yeah.
So
us doing 50% is more restrictive than some states. So
sure, but it's also advantageous to those who are trying to qualify.
yeah. We've had a lot of people trying to get their qualifying education that have told us that they were unable to get hours because of, I mean, Randy, I know you've brought this to my attention. They were unable to go to certain classes or drive here or there. So
Right.
I mean, I've got 2 trainees right now, and they're both in class this week. One's fortunately here in Nashville, the other's somewhere up in Ohio. I don't know. I mean, they just have to go when they can get them, you know.
It imposes not only a delay in time, but a bigger cost in many instances because of the travel costs. So we wanted to make that more flexible.
And I will tell you, as the person who has to go in front of the legislator and present these type of rules, this is something that's going to look very good on behalf of the commission, because it appears as though we're welcoming more people into the profession, and we're not stating, you know, we're only accepting in-class hours. So.
Well, the other thing is what Rex related to earlier today, and that is we also don't have as many qualifying education classes being offered.
Well, coming online, because a lot of the qualifying ed has already been set. And in the state of Tennessee, we offer, more qualifying ed than any place else in Southeast. And it's available here in our state for this reason. I go back to, it was an Aero conference last year in Tampa, and I kicked myself for not getting the guy's name and what state. It was either North or South Dakota. And because they're up in North or South Dakota, they don't have a whole lot of classes. So they, it's open for 100% to be online. And they've run into issues with that for those that have taken a lot of online courses.
I mean, I have an issue with 100% online. I think.
Yeah, my concern in sitting in here doing interviews, that's one of the questions I ask to get a little background on the individuals. Where did they get their education? And you only get, in this profession, you only get one opportunity to get them educated. Everything else is CE, unless they're willing to go beyond the minimum. It's easy to say right now to lessen it because we're in, some opinion, good market time. But what happens when the market flips? And they care about value again. But I'm concerned. I'm proud that Tennessee has 100% classroom because they're getting more than just a classroom. They're getting the experience being around other people, getting the experience with the instructor. They're getting more knowledge than just the book education, the book work. But that's a concern I have.
So I guess my question would be, does your concern, I mean, would you be okay with 25%? I mean, that's what, I mean,
If it's a matter of negotiating, I'll stick at 100% and we'll see where it goes. But,
so okay, then my next question would be, Randy, do you want to go piece by piece on this? Do you want to do this portion and vote on it first, whether you want to keep this in or not, and then vote on the fee reduction, or do you just want to pick at each rule? I mean, we could go one by one here if you wanted to.
Well, and I'm on the other side of this. I wouldn't mind, especially for qualifying education, to be able to get 100% online. One, sending someone through those courses right now, and some of the instructors that are available who aren't teaching a lot. Number two, you can get a college degree online. You can get a master's degree online. I feel like if you're getting your qualifying education, the reality is your sponsor should be teaching you what those courses are, giving you basically a prerequisite, and then your sponsor's responsible for teaching you how to run your business when you get done.
I think there's a breakdown somewhat on the supervisor. Just sitting through some of these interviews, my biggest concern isn't the trainee, it's what they were taught with the supervisor. And at one time, I wrestled with the fact of having a classroom setting for some experience. But in sitting through these interviews, I think I am in an agreement, maybe give 500 experience hours to let them sit in a classroom with a certain case study and let them go through the process at least one time correctly. And not in a situation where this report comes in and it's got to go out Friday and rush it through. Let them work through the process and know everything that's going into the report. And I think that will make a lot of the trainees better overall.
I agree with you 100%. Absolutely. If they had a case study program where they had to spend X number of months and maybe so many hours per week doing that, we'd have better appraisers in the state.
Yeah.
But I think on top of that, though, you would need one for a commercial route and then one for a residential, cause.
All right, let's go back to we have on the table.
So I'll finish explaining the rules a little bit. That way we can just talk about them in an overview. On page 2, the second part of these rules is the fee reduction. Randy, I don't know if you want to speak at all to going to the legislator. You and Roxanne, I can cover that. But fee reductions are a big thing right now throughout the department, and we were able to find a couple fees to reduce or eliminate in their totality. We are deleting the application for initial appraisers. We're deleting that $125 fee. And we're also reducing the license or certificate issuance fee to $325. So I think that was all of our fee reduction.
Renewal fees. Anything on renewal fees?
That fee will actually go down on everything. So that 125 for the application is part of an initial, it's part of your renewals, so we're gonna hopefully be able to reduce all of the different categories.
When we
because
get to renewal section, we'll see reductions there.
There'll be a small reduction as well.
And the rationale for the commission behind that is, some weeks ago, I guess, and I don't even remember when, I had to testify in front of a Senate hearing in regards to fees and commissions. One of the things that they were real big on was us not having the current surplus or reserve that we have, which is relatively substantial for our small board. And so they asked what we were going to do to reduce fees or to reduce that reserve, and this is part of that answer. So we just about have to do this. So and we're not, don't get the wrong impression, all commissions are having to do this also that have a surplus. Anything else, sir?
Yes, there is one more. So I'm sure many of you are aware that AQB is changing their education and experience requirements effective May 1st, 2018. By statute, I believe it's 6239-303, we adopt the AQB standards. But then our rules, we adopt them in totality, and then our rules, they would just spell out everything that the AQB did. So when Roxanne and I reviewed the new AQB standards, we decided to simplify our rules. So if you'll notice on the bottom of page 2, it discusses the general education, and we're just taking out essentially everything that's unneeded, and it will just say the applicant shall satisfy the AQB general education requirements. So it's just that way in case, in 2 years, if they decide this is not what the right decision and they want to go back, we're not doing a rule update all the time. So we will keep all of the AQB information on our website. So if applicants ask, for instance, what are the paths to get this license, we can send them to the right place. So it's really just a simplification measure on our behalf, so we don't have to do this every.
Theirs just parallel theirs.
Yes.
Okay.
So, if you haven't had a chance to review the AQB updated standards, it's
On page 62 of your iPads are the 6 paths now.
Sarah, is that something we need to vote on, or it just?
what we will need you to do is vote on these rules as a whole of whether you want me to proceed with the rulemaking. The AQB, no, you don't need to vote on because you've already adopted it by statute. So that will go in effect with the state of Tennessee on May 1st, just as it has.
Okay, so sum up and for the commission what it is we're going to be making a motion for when you say the rules.
You just need, basically I need someone to make a motion to proceed with the rulemaking process as laid out in these rules, in this draft.
Okay, and in this draft, does that include the 50/50 on the?
This includes all of that.
Okay.
So if you all want to make any changes, that right now would be the time for you all to tell me what changes you want to make, any discussions.
Be easier to just take it page by page. Like, I don't think there's any, like, I look at page 10 and that's good,
Yeah, and we can do that. I mean,
Or
we
do
can
you
go.
want it? Because I think, is it Jim, somebody's 100% education, somebody's not. There's going to be a few things that
So-
are going to be sticky. So
Probably what
why
would
not get the
be-
easy stuff out of the way and then
Yeah, probably what would be best is I'll go rule by rule. We'll just kind of go through it. We'll start on page 46. They're kind of broken up on what I did, whether I changed something or not, and we'll just go by each if we have changes. So if you look at the first one, it's just 1255.01.02. We're adding the definition of AQB. I'm sure everyone's okay with that. It just wasn't referenced in our rules prior to that, and since we're now using the term AQB, we need to define it. The next rule is 1255.01.04. This is for fee reductions. As you'll see, the first two fees are eliminated for application for initial, and the third one is reduction. And then 1255.01.05, it starts on the bottom of page 2. Those are updates to AQB, and they bleed into page 3, where we deleted everything that you had to have.
I would make a motion that we approve the proposed rule changes all the way up to Rule 1255-01.05, parentheses 1, parentheses B, 1. Everything prior to that.
Second.
Motion's been made and second to approve the rule changes.
In layman's terms, through half of page 3.
Right. Well, okay,
The first three rule changes.
okay, the
Let's go.
first three.
Yep.
All right, any discussion? All right, we're going to vote on the first three rule changes. All those in favor say aye.
Aye.
Any opposed? All right, Sarah, that carries. Up to 3.
Okay, on page 3, Rule 1255.01.05, 1B. This is, again, let me make sure this is, so here's where we probably need to discuss a little bit. This is the course versus classroom. This changes it to, it removes the word classroom so that it could be online or in class, and no more than 50% online.
All right. Recommendation's been made to remove the word classroom and include, to insert the phrase, no more than 50% online or distance learning, as some people call it. Any discussion or a motion?
Yes.
Okay.
I have many students that take classes online and then come to the classroom on the same course, the same class, because they say they didn't learn anything. They didn't pass the exam, and I don't know what a percentage would be of how many people that might be, but it's a significant number. And so they would come to the class to learn something. And I would just simply ask them a question, what did you learn? They said, I didn't learn anything. That's why I'm here. As has already been stated, we have some in-class courses that are not maybe fulfilling their obligation to teach the students the proper things, but there are many classrooms that are, and that should the students should investigate courses and who the providers are and find the best that they possibly can. It's up to them to do that. To sit in a course and read the newspaper on the back row, or to do your appraisal work while the course is going on, an instructor, first of all, that would even allow that is not is not worth sitting in the room with. But sometimes that happens. I agree with Rex in the sense that the reports that I review, and through the years I have reviewed a lot of these reports. It shows that they are there is a great deficiency in their understanding of the appraisal process. There's a great deficiency in the understanding of standards, which leaves us with a state full of appraisers who lack competence in a lot of areas, and that's why we see them coming in here, or their files coming in here. So, bottom line for me, we're going to have to weigh and balance convenience versus quality of education. I will vote for quality of education. If they want to be an appraiser, we're all for convenience, but the quality of their education is more important to me. And so I do not think they'll get the quality in an internet or a distance education or in an online course. So I would move to eliminate no more than 50%, and we would maintain 100% classroom education.
I would also just make the point that this isn't saying that everyone is going to do this. This is just an option. As someone who went to law school, I was able to take online courses in law school, and that was an option for me. I tend to be more of an in-person learner. I took the choice of taking the class in the classroom. That was my choice. When I studied for the bar exam, you could take it online or you could take it in the classroom. I chose to sit in the classroom every day. My best friend chose to take it online. We both passed the bar exam. I get it, sometimes you don't learn as much, but I've also sat in continuing education courses as an attorney and played on my phone the entire time because it wasn't even applicable to what I do. So
I'm glad we have that on recording.
I have a question.
I would just ask it to be considered.
For the qualifying or the continuing education that an appraiser takes in class, they're required to go sit in a class, correct?
Yes.
Right, but you sit in the class, and when the class is over, you walk out. If you take class online, are you required to sit through the class and then pass questions at the end that determine that you were paying attention?
Yes.
If we're saying that in-person classes are far superior to online classes, why aren't we making continuing education take an exam at the end to make sure that they've retained the knowledge or learned something during the class?
I mean, I know that my mother is a real estate agent in the state of Indiana, and if she chooses to take all of her continuing education at once online, there's a required exam at the end.
Correct.
As opposed to me, I can only take so many hours of my continuing education online versus in person, and there's no exam.
I guess my point is we're talking about appraisers who, when we get reviews done, that the appraisers are lacking. But we have nothing in place that says, okay, you're going to take these continuing education classes, but you don't have to learn anything while you're sitting through them. Now, we'd hope as a professional that they would, but we know that's not necessarily the case.
I guess that's where I'm thinking is trying to keep it a profession. And my concern is the movement is we're more commodity, and if we start lowering the bar, what's going to happen to the profession? And there is more than just the book material that you're learning in class that you don't get online. And I could go through the list. It's networking, meeting other guys that you can call up, and if you have an appraisal question, you can get information. It's a networking. It's hearing, and I understand the instructor side. There are good and bad instructors. We're approving instructors, are we not?
How's that I've not been a part of that, so I don't know how that process works. I don't know when we look at an instructor if we say they look good on paper.
Yeah, and it depends on where they're getting their education. There's opportunities to get feedback and all as far as that. But appraisers by nature are very independent, and I'm not going to say the vast majority, a big chunk of appraisers, because fees have been going down, or trying to reduce costs, and they end up working out of their house, and they're not. And fewer appraisers are belonging to professional organizations, so they're not getting around other appraisers, and they're becoming stale. It was mentioned earlier, some of these complaints are guys that have been in the business a long time. Are they, and this jumps into a whole new realm. All right, is there a problem with CE? Should we have a recertification after 10 years
I think
or so?
that's, if all these guys had to take courses, majority of the ones that probably we looked at today have taken their classes in a classroom setting. Probably the older guys are less likely to do an online class. So what are they learning in the classroom?
Well, that's more dealing with CE as opposed to qualifying ed. And qualifying ed is a foundation. And, in interviews that I've had in there, I've asked questions that they should know, but they didn't get. And that's why I ask where they got their education, because it's twofold. It's find out a little bit about that person, and second, are they getting the proper instruction?
I took my qualifying education classes from Mr. Atwood, and during my first 2 years as a trainee, I pulled those books out many times to go back and look, because he was extremely thorough in going through the information. Like I said, I sent somebody else to the classes recently, and it was scary what they didn't cover.
That wasn't my class.
That was not your class, but he is taking your class in the summer, because I knew the history. So if we can say we've got a handful of very good instructors, But the rest of them are, why are we not allowing at least some of the education to be taken online?
Just to clarify a point, you approved instructors this morning, whether you know it or not.
Yeah, I saw that.
Okay. Now, I have a question. Can you, Mr. Johnstone, can you relay or share with us any concern that your two trainees have about qualifying education, having to go to Ohio or wherever?
They continually ask me why they can't at least get some online.
Well-
From the standpoint, now they do learn things when they go to the class.
Sure.
They're not saying that the classes aren't instructive.
Sure.
It's just, most of these individuals, they're young, they don't have a lot of money, it's very expensive, and they're trying to make a living and pay the bills, and it's just very difficult. So it's about economics with a lot of these young folks.
Well, I had a gentleman at home ask me, and I discussed it briefly about the situation. And he said the course that he's trying to move from licensed to certified residential, and the course that he needed was going to be offered, and this was in January, it was going to be offered in Tennessee in April, but he could go to San Diego, Dallas, or Chicago right now and get it.
Right.
And so it was just more economically feasible for him to wait until April.
Yeah, that's,
And so, I think it would be different if somehow these courses were offered, and they can't be for financial reasons. I mean, I'd say every week, but every month, I think it would be different. But it's that they're so spread out.
here's the reality of it. I mean, my guys, they've got a calendar there, and they know what they've got to get
Right.
to be at license. And they know where they're being offered, and they can't take and fly to Seattle for a week. But they can get in their car and maybe go to Louisville. And so they have to balance that with working. And some of these classes, they're not offered very often. So you've got to physically find where it is and then hopefully be able to, get there and make it happen. Because the flip side, the providers, if they're not making money on those classes, they've got two people sitting in a class in Nashville, they're not going to provide that thing once a month. They're going to provide it occasionally throughout the year in a large environment, urban area, where they can at least make a profit. So it's not only, all sides are looking at it from the economics.
Sure.
The providers as well as the participants.
Well, and that's also why we included distance education. I know that we're allowed to do what they call WebEx, and you can set through a presentation that actually is live, so it could be Mr. Atwood teaching, and I can actually ask questions and be just as big of a participant sitting in my office or sitting in, my bedroom as Randy could be sitting in the front row. So, I mean, he doesn't sit in the front row, but...
On the qualifying education as well, they're still required to take the classes, be an apprentice or trainee, and then pass the exam.
Correct.
So at least with them, there's multiple steps that they have to go through. We're also discussing how all the requirements are changing. I would think you'll see somewhat of a increase in the amount of people who are trying to become appraisers in the next couple years.
Let me ask you a question about the reciprocal state or the adjoining states. Of the 7 that abut Tennessee, can you tell me which ones have some CE online, some?
Talking just for qualified education,
Qualified,
right?
yeah,
So we're
not
not looking
CE.
at
Yeah,
changing
qualified,
anything
I'm
else.
sorry.
I think we are one of, and either Rex or James would remember, we're one of maybe 6 that have no online for the qualifying.
But that's 6 in the entire country. That's not the
believe
6
so.
that touch us. I
No,
know.
I mean, okay,
Yeah.
no,
We're in the
Kentucky-
minority
what's
that
Kentucky?
have the 100% strictly
Okay,
in
so-
person for
So what is
qualifying.
Kentucky's? Do we know?
I don't know it.
North Carolina is, you can take 100% qualifying
Several are
online.
100%.
Kentucky's was, I just talked to Larry Disney not too long ago about this. I'd have to go double check, but they have some
What
that you can
about
take online.
Arkansas,
Don't know about Arkansas.
Mississippi?
Mississippi, I want to say they had a percentage that you could take. Theirs wasn't all online. Not sure about Alabama.
Let me ask you this, could we skip this one as an effort to get through this thing, and we can get back our day finished, and maybe have Mr. Harris pull that information on the surrounding states, and then come back to that? Because we may be here all night if we don't move.
If that's going to make a difference for us to decide,
It'd be important
yeah.
for everybody to know
Yeah.
what's available.
I don't, keep in mind that I don't think anyone is recommending the 100%. I think that's a given. It's a matter of, do we find the fixed number that everyone's happy with, or at which point are you comfortable with?
Well, and one of my
being the
answers,
same?
I know I did reach out to many of the executive directors and attorneys that I knew, and I got a response from the attorney in North Carolina and Larry Disney. And Kentucky and North Carolina allow applicants and licensees to take online for both qualifying and continuing. North Carolina was pretty sure 100%. Kentucky was not 100% that I can recall.
Do we know what the number was?
I'd have to go back and
Can you, okay.
I don't know, to be honest with you, and Brad's fantastic what he does, but I don't know that we're going to get within our time frame the percentage, because it's going to be buried in their rules unless he's able to reach a person that knows them. It's going to be.
Rex, you want to add something? Well, I know, but I'm recognizing you if you want to add something.
Well, one thing, and this is a rabbit trail, and it's not, but if we're going to look at education in the supervisory class, I think we're about the only state that requires 7 hours, and most every other state only requires 4. And there's really, I think, only one provider in the state of Tennessee that offers the 7-hour supervisory class, and because online classes only do it for 4 or 5 hours, and so that is a fix if we're going to look at anything to sort of speed up the process, because they're required to have the supervisory class. Why not reduce that from 7 to 4?
Okay, hold on.
Just a thought.
Mr. Button, you have a question?
I was just going to ask, Mr. Chairman, if you're going to delay, I just wanted to make some comments because I didn't want to have to come back if y'all are going to delay this to later. So that
We don't want to come back either, so you're going to have to join us. Go ahead.
No, two things that I really wanted to bring up here on this issue as an instructor as well. So I'm speaking from that perspective. And I've had some of the same experiences as Commissioner Atwood. But in the upper division classes where we get people who are trying to qualify for general certification, I teach the income classes, which are very problematic. In other words, there's a lot of problems. And so what happens in these courses, I can tell you just from experience, is that I'm always there early before class and late after class, working with students through those problems, because it is very intensive on the income courses that they understand how to do the problems. And it's over half of the exam. And that's what they're going to face too when they go for their general for certification exam. So it's extremely important to those students at those courses for general certification that they have that hands-on, one-on-one that you would not. I don't know how you would ever get that in a distance learning environment. But I'm just saying that is extremely important. That was one of the things I wanted to at least bring to your attention.
Okay.
Good point. That's a good point. If I can jump in, that's one of the things that my trainees did say that have had the income courses. It said they certainly would have to be there to get through those courses. But what they did also say is some of the basic stuff, just to get started, there was no reason they couldn't do that stuff.
Well, I mean, Jim and I also teach the principles and procedures courses throughout the country, and I tend to agree with you on some of that. But there again, one thing to also kind of understand is that we want these folks to be able to, when they set for their state exam, to have a high probability of passing that. And I think that's the entry level as well to getting more and more people in the profession, is so they don't get discouraged, because now our pass ratios, are under 50% on these exams. So quality of education is extremely important. Also making sure when they leave those courses that they're prepared to sit for that examination and pass that examination. So I think that's kind of incumbent on the providers and the instructors And then one other thing I wanted to make a note on too is quality is important. And if I've always felt the organizations do a really good job, some of the professional organizations, of making sure they have credible instructors. And they monitor those instructors by having the students to fill out their evaluations at every course. We don't have that in the state. Some states do require that, because I teach in other states where they do require an evaluation every time a course is provided, whether it's a continuing education course, as Commissioner Bennett was speaking of, or as a qualifying education course, that they are getting feedback. So once we approve a course or approve an instructor, they may be teaching 10, 15 years, 20 years down the road. We don't know the quality of what is being provided to our students. So having some type of mechanism by which it's required for every course that's taught in Tennessee, whether it's CE or qualifying, to get some feedback through the commission. And that way, you as commissioners can monitor and making sure you're getting the highest quality of instructors out there.
Okay. Thank you for your input.
Yes, sir.
All right. Discussion has been brought up that we, Ms. Matthews, that we put this section off until later. Will that satisfy you for right now, so we can get the rest of it done?
Normally, I would say yes, but we'll probably have to come back with a full proposal next month or next meeting, because our answers to the questions that we would have you approve are intertwined for all the rules. So this would be us having to go through and,
Okay.
I mean, unless you're just going to give me the right to answer these questions. I mean, Roxanne and I could probably answer them.
I think that would be, I appreciate that, but I think that would be sort of incumbent upon us to review at least what you're
Yeah, I would.
gonna
We
answer,
would probably
so-
both prefer that you.
Okay, good. Well, and then let me ask the commission this. Is there anyone who wants to make a motion in regards to that education that has been proposed?
Chair,
Yes, sir.
I already made the motion.
I'm sorry.
I don't think anybody heard it.
I
I
know.
didn't get a second.
I know that I did not hear it, sir. I'm sorry. Would you
That's
repeat
fine.
it?
I make the motion that we remove the phrase "no more than 50%," et cetera, and that we maintain 100% classroom education
We're qualifying.
for
Qualify.
qualifying education.
Okay, yeah, because I just need you to really give me that guide so I can go back and rewrite these. If you
I'll
all vote
second.
and agree on that.
Okay. We have a motion and a second to remove the word classroom and remove the 50% and go to 100% in-person qualifying education.
It would just be a no rule change.
There's no
No
rule
rule
change,
cha-
then
oh,
we're
okay.
leaving it alone. It's-
Okay,
it
no
would
rule
Be
change.
leaving qualified.
Okay. Does everyone know what we're voting on? All right, all those in favor say aye.
Aye.
All those opposed?
Aye.
Aye.
I'm going to need to do a roll call, because I don't believe we've got anything fixed. So, on the motion to take out the change in the rules for qualified education as proposed by Ms. Matthews to be 50% online and 50% classroom, and take it out completely to where it remains that Tennessee would still be 100% in person. We have a motion and a seconded to remove. Let me go real fast. Mr. Randall Thomas, you're voting yes, take it out, or no?
I'm voting to leave it in, the 50%, leave it in.
Mr. Rex Garrison, you
Take it
seconded. Out. Thank you. Mr. James Adwood? You
Take it out.
Okay. Mr. Mark Johnson?
Leave it in.
Mr. Jason Bennett?
Leave it in.
Okay. As we have it, it's 3-2. The numbers to leave it in would be changing the qualified education to 50% in person and 50% online.
Would like to add one thing to that, though, that it's for, if there's a way to differentiate between upper or classes that you're taking toward the end of your licensing that are more difficult. It seems like we ought to be able to say, if it's a basic class, that you could do it online. If it's an income cap class, you got to go to a class. I mean,
Could we not say you can take these classes online and these classes are required to be taken in classroom?
yeah, I think it would, differentiate those, because I'm struggling with that. Some of the stuff I don't think needs to be online, but then there's certainly some things I think there shouldn't be a reason why you couldn't.
And I have a question for Mr. Button. Do you know if they even offer the class you were referencing online?
Yes, because it's a qualifying education course. It is. I think going back to what Commissioner Johnstone says is the classes that you're required to become a trainee, then those are the principles and the procedures, and the USPAP class and the supervisor training class, which are the 4 classes that are required. Those are the preliminary classes. Everything above that, whether it's specifically dealing with sales comparison approach, cost approach, whether that's residential, non-residential, general courses, or your income courses, or report writing, those are courses that are a little more intensive. And I assume, as the remarks I made earlier, I think it's extremely important for the benefit of the students is to have that in classroom.
Maybe there's a way to put it where.
Does that sound like something you can do, Sarah, that we can split those up and say or define a difference between basic and upper levels?
So
Can I make a motion
Maybe
to that
even say
effect?
up to so many hours in lieu of 50%.
I mean, I guess what we could do is, so just under licensed, under appraisal education, it would change to 150. It would just say course hours or hours of courses, and then it says in subjects related to real estate appraisal, and then it goes through. I guess that you all could go through each of those and say successful completion of 30-hour course in appraisal principles, which 50%. I mean,
What
I guess we could go
about
through each.
for a trial, do the trainee courses online and everything else be classroom, and we see how that goes?
Yeah, so that would be a rule change, and for us to go, this is going to sound really crazy, but for us to go to the legislator and say, hey, we're making it easier for trainees to get in, and then try to go back, a year later and say, yeah, that didn't work, we're changing it back, they're probably going to shut us down. I mean, that's just...
One of my main concerns is, and I hear it all the time and I'm sick of hearing it, is millennial. But you're going to have a lot of people who are going to say, you're going to have a lot of younger people than I are going to say, I got to take all that face to face and travel. I'm just not going to do it.
And I see what you're saying, and I mean, I'm hoping, me as an individual, whoever I was working under, I would probably try to talk to them and say, I'm allowed to take some of these online. Are there some that I shouldn't take online? And, maybe we don't go through each specifically and say, take the higher ones online, take the lower ones. But when we talk to these individuals and they call in and talk to Brad or somebody, he can say, the commission, has not technically opined, but, they've said some of these classes are better taken in the classroom. Because we get questions about the courses a lot. And I mean, if someone asks me, I'm just going to take this basic principles class, and I would, can you take it online?
Do we know what Dr. McCara's stance is on this? Has he stated whether
I know that we talked about this a few meetings ago, but I don't recall exactly. I mean, I'd have to go back and pull minutes from a couple months ago just to see. Because I know we talked about this before I wrote it into rule and brought it before the commission. We talked about this.
Is this the final time we're going to get to look at these today?
This would be the last time in front of you all, unless you wanted to table this and think about it. Because I know I came to you all with a proposal, I think, in November, and we tabled it. So.
Will there be a public session on it?
Yes. I mean, this would follow the normal course, but it's starting out. We're not there yet.
This would go proposed rule right now. We would not be doing a rulemaking hearing unless once we filed these, there was a need to do a rulemaking hearing.
So during the public comment section, if we hear people that are a lot and we decide we want to change, can we change this at that point?
Here's how we would do this, since we're doing a fee reduction, and we could start off with the rulemaking hearing and go that route and have a public hearing. So you all would come in, we might be able to get it done for the next meeting, where we would go through a whole session with the court reporter and people would come in and ask questions and ask you to change things based on this proposal as a whole. So let's say we passed this and said we're going to have a rulemaking hearing on these rules. People could come in and say, I think you're absolutely crazy for doing 50%, and you all could say thank you for your comment, but we're going to stick with what we've done. Or you could say, okay, we had 20 people lined up here that think it should be 100% in the classroom, so we're going to go back and change that. So at that point, that would change. If we go the proposed route, which normally is what we do because it tends to be a little quicker to get rules in place, we would send these over to the AG's office. They would approve them. We would file them with the Secretary of State. Now, once they're filed with the Secretary of State, that opens that 90-day comment period. If an association as a whole opposes our rules, we have to start over and do the rulemaking hearing. Or if we have 10 people object to the rules, we have to start over at that point. So that's kind of the routes. And I mean,
If you have 40 people come in here and say, hey, we think it's wonderful, and 10 that say they think it's not, we have to change it again?
no, if you do the rulemaking hearing on the front end and you have 40 people that come in and say, thank you so much, this is going to be great for the industry, that's actually your part where you all can look at them and say, we appreciate your comments, but we're going to stay with what we have. I mean, someone could come in and say, you're absolutely crazy, and you could look at them and smile and say, thank you, but
What did I hear you say about 10 people?
that's when, if you go the proposed route.
Yes.
So like we normally do with all of our rules, the rules
Yes.
that we have.
Yes.
If you have, when you file them with the Secretary of State, there's a 90-day window. If 10 people object and say,
During
I
that
object.
90 days?
Yes, I
Okay.
object to these rules.
Okay.
Once we get 10 individual comments, we have to start over and do a rulemaking hearing.
Okay, so if you had those 10 individual comments that say, we don't like what you did.
And
okay.
they give us, they say this rule,
Okay, I understand that, but you have 10, but you have 500 that say we think it's wonderful.
it doesn't matter. As
The
long as you
10
have the
still
10,
overrules the 500.
the 10
Okay.
objections or the one association objection takes us back to the rulemaking hearing.
Okay.
So then you go through the whole process again. You do the rulemaking hearing, you change the rules if
Sure.
you want to, you file them with the Secretary of State again, and then we still at the end of the day have to go up to GovOps in front of the legislative body, and people can still come to that and speak negatively on the rules.
Sure.
So,
Sure.
So if we all agreed on this today, how long till this would even go into effect?
so I mean, normally what we try is 7 to 9 months. So if you all voted on this exact packet and we went through, I would send these to the AG's office for pre-review. They come back.
So we're talking everything that we're looking at, the fee reduction, all of it.
Yep, we're looking at 9 months.
Okay.
That's where we're at. But if we get an objection and we have to start over with the rulemaking hearing, we're looking at 12 to 15. Easily.
Well, Mr. Chairman, I want to change my vote to out on that. It just, have we voted for it? Well, we have, okay, that's right.
We've done roll call, so we'd need to change and have a different motion, I guess, and readdress. What I do
That's
want to
okay.
caution us is that right now we've got them all traveling together. We kind of thought, because it had been addressed before for the qualified education, that we'd be able to agree, so it made sense to travel together. If we don't, or see it as we want to debate it, or we have to look further or do research, we may want to separate the rules so that the fees get to travel, and we're going to double check and make sure that the renewal fee, that everything's in there, so that the AQB criteria falls in there, and we reduce our more stringent rules right now, because we're adding 24 months, where now the new paths are a little bit easier to follow. If we then have the rules travel and everybody agrees to that piece, then maybe it's still worth looking at this piece separately and guide us on what other study we could do, what else we can bring before you, so that maybe then all 7 members are together and we have a full agreement. I mean, we may not, but
Yeah, because we could walk through the questions right now, and I could tell you what I would take out if we take out the course versus classroom, and we can address that in July, because from what I'm hearing, I'm probably going to have to do a rulemaking hearing anyway. I have a feeling I'm going to get objections.
That was what I was going to suggest, Mr. Chairman, is if, in order to object to this, you're going to get 10 objections.
I'm gonna get 10.
And then it's going.
We're going to get 10. I don't have a doubt in my mind.
And then it's going to throw all of these that you've already agreed to, the
Right.
preliminary three,
Right.
into this process of a rules-making hearing.
Right.
So if there's a way to divide that
Okay.
out, because this is going to be something that's a little more contentious.
Okay. All right. So,
We just normally like our rules to travel together. I mean, we
Okay.
just passed 2 sets and it was a pain.
okay. So
Yeah.
do I
So-
hear, let me just say this. Do I hear a motion from this commission to, again, have you travel in 2 sets and take this first section out?
Can I ask for it to be 2 sets, one with the fee reduction and the AQB standards together,
Yes.
and one with the course versus
That's
classroom?
exactly what I'm saying.
If you say that,
Okay.
I can separate those.
So moved.
Okay, I have a motion. Do I hear a second?
Second.
I have a motion and a second to have Sarah divide the 2 in the way that you have described it. Any further discussion? All those in favor of this new motion, please say yes.
Yes.
Any opposed? Motion carries. All right, we're going to separate them. Now, where do we go from here on the second set?
Okay, so I would. We probably don't need to walk through all of the rules because that would just take up too much time at this point. So if you'll go to, let me see if I can find what page it is in the. I need to go to questions that are answered. It's going to be on page 58. So we're required, when we send up rules, to answer some questions. The first question here just asks what types of small businesses and the identification and the estimate. So we wrote up something there. I think what I would probably take out, if we were just doing this for the fee reduction and the AQB, is that last sentence in the first paragraph, which talks about qualifying education and online. I think the rest of it addresses what we're looking at.
All you want to do is take out that last sentence.
Yep.
All right. Does everyone understand what Sarah's saying? Do I hear a motion to approve? Oppose?
I move we approve.
Okay. Motion's been made. We approve to take that last sentence out of first paragraph in regards to education. Do I hear a second?
Second.
Motion's been made and seconded to take the first sentence of the last sentence, first paragraph out. Any further discussion? All those in favor say aye.
Aye.
Any opposed? All right, Sarah.
Okay, number 2, that's Roxanne and I, so we can skip that. Number 3, statement of the probable effect on impacted small businesses. Let's see what we would take out. The proposed rule would affect. So essentially, we would just eliminate the proposed rule would allow applicants and current licensees to take a portion of their education online or by distance. Take out that paragraph or that sentence. Sorry.
All the way to the end.
Last sentence would stay in because that's AQB standards. So just that middle sentence would come out that relates to
What number is this, 3?
number 3.
That again goes back to the education. All right. We're going to vote on taking the middle sentence of section number 3 out that has to do with education.
So moved.
Second.
Motion's been made and seconded to take the sentence out of the middle of section number 3. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Okay, Sarah.
Next one we need to go to is number 5. I would probably be removing the first sentence because Kentucky and North Carolina, that applies to online. So we would, and understand, we may bulk up these responses when we're doing it for fee reductions if we come across some numbers or statistics that we think are beneficial. But it would just say it is our understanding that several states will be adopting the AQB standards As such, these rules are believed to be consistent. Take out the first sentence.
Well, you need to qualify, okay, take out the first sentence, sorry. We're going to remove first sentence on section number 5. Do I hear a motion?
So moved.
Okay.
Second.
Motion's been made and seconded, thank you, gentlemen, to take out the first sentence of section number 5. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Okay, Sarah.
Number 6 is me. Worry about it. Yep, and then the rest of it is just Roxanna and I. So with those changes, as long as you're good with them, we will move forward with 2 sets of rules. The fee reduction and AQB standards rules will not come back in front of you. We will continue on with the proposed rulemaking process. The online will come back in front of you, most likely, as a rulemaking hearing. So
Do you anticipate that being in July?
hopefully, if we can get everything, we have to give 45 days notice and all that good stuff. Let me double check with you all. So we're going to draft these, and we have to send our draft for the rulemaking hearing. Is it okay if we leave it with the online right now and the 50% and then have public comments towards that? Is that your wish?
That's what we voted on.
Yes, but we had Mr. Johnson change his mind, so I don't know that motion.
I don't know, we had already passed that, we'd have to bring it back up.
Because otherwise there's no rule change to have a rulemaking hearing on if we leave it the way. So that's the biggest thing is.
Can we remake a motion with a different percentage?
That's
We
fine.
started there. Yes, you all can propose a different change, but I think if you're leaving it 100%, then there is no change. I just don't know that we're in agreement. And if you want Sarah and I to do any research to present,
If you
And bring it back
want
in
research
July.
and bring it back, then the rulemaking hearing would not be in July. We would come back with another proposal.
In this new proposal that you are talking about coming back with, it would be something in regards to a percentage online, a percentage all in face, or what are we?
My proposal, without you giving me any guidance right now, would look exactly like this one does, and it would just come back for discussion. Unless you all are telling me right now, we want to do 20%, we want to do 25%, we want to do 75%.
and based on the fact that Tennessee is one of a handful, 6 or 7, that doesn't have, that's at 100% in person, our research may not change a whole lot. I
have a further question or statement on that. Mr. Atwood and Mr. Button both travel to multiple different states to teach. So that clearly shows you there is a lack of educators out there. That the fact that they go to multiple different states to teach. I just don't understand why we wouldn't allow, if you're going to be a licensed appraiser with the new requirements, how many hours of classroom work do you need? Does anybody know that off the top of their head?
For license, you need 150.
160. I thought it was 160.
150
150.
So
License.
for a license.
for license.
Your trainees are roughly 75 hours plus your supervisory, which doesn't count, I don't think, anyway. It's part of, so that'd be 50% for a license. And as you go up to certified residential
200.
general,
Yeah.
that 75 hours would be something less than that.
And the time frame now to become licensed is 12 months?
18.
18?
Under the new one, 18.
Okay. So they have to fit all that time in 150 hours classroom in 18 months if they go through the process as fast as they possibly can. Does anybody else think that is very difficult to do? We're offering the sponsor course about 4 times a year in the state.
Well, that's something that we probably should look at it changing and drop it down to a 4-hour and
Those are the other kind of discussions we need to have, because if I'm coming back with the course versus classroom, and you think that supervising person needs to go, I wrote it down, from 7 to 4, that proposal needs to come up now for when I come back.
By the same argument, we're saying we're concerned about some of the people who are sponsors, so let's drop the requirement to become one.
The reason for the 7 and 4 originally was the 3 and the 4 is the 3 hours is related to state of Tennessee requirements, and the 4 is more basic requirements. Because we felt when we voted on that, I don't know who all was here. Some of us, I don't know if everybody was on the commission then. Probably I was the only one here at that time. But our thought was there's a lot of things pursuant to Tennessee rules that they're not hearing, and we want to make sure they got educated.
Sarah, am I correct in saying if the only way you can bring a rules change back is if we do nothing?
No, I need some guidance. I mean, if we decide today we're going with 100%, there's no need for me to come back with a rule because there's no change.
We've already
to the rule.
decided we're not doing that. We took a vote and we said we're going to go 50-50.
Yeah, and I was waiting for you to go back to that because I think Mr. Johnstone may have had a change of heart.
I was reconsidering my vote on that and going and taking it out, but we haven't went back to it yet.
I mean, is a compromise 25%?
And I mean, here's what we can do.
To be quite honest, I would like to hear there's 5 of us right here and 6, we're making, and I'd like to know, this is a big, big decision. And I think we need input from people throughout the state. Because
Well, then, okay, and I agree with you that we need input from all different avenues. If we let you go with what we have voted on, and that is a 50-50, then you'll have to put it out there for the public to make comments on, right?
What we would probably do is I would write up these rules and we would do a rulemaking hearing.
Okay.
Because from everything we've seen, it's contentious with 5 people. It's going to be contentious with the whole state. I
Right.
mean, but then if we're going to add anything, I mean, if Rex wants to add the supervisor, we need to know those kind of things because I want to make sure this is a complete rule packet. Because when
Okay,
we get
I understand
to,
that, but let's just talk about right now. We'll come back to whether we do anything with the supervisor.
because we have to send this to the AG's office
I
to
understand
make sure
that,
it's
but
constitutional
when-
before
Right.
we
and
can
when
even
you,
have a rulemaking
and when
hearing.
you send that in the way that we initially voted, and it says we have a rulemaking hearing, then you have a public 40. I think you said 45 days. Is that right? The public has 45 days to comment on it or something.
We have to give notice of the rulemaking hearing
Yeah.
45 days out.
Okay, and
They
then
don't have that.
and in the rulemaking hearing, the public can comment.
Anybody can come to the rulemaking hearing, and they will come and address you all, or they will
Right.
send their comments via email.
Okay.
We will probably be here all day for this rule.
I understand that, but at least at that point in time, someone other than us will have some
Yes.
kind of say about it.
I would say by the time this goes through the AG and all of that, this may not make it on the. We're going to be stretched to make it on the July.
Okay, no problem. Yes,
So-
sir.
I will say this, the last rulemaking hearing that we had, the only person that's in this room that I remember, Mr. Atwood might have been there, I can't remember, was Randy and I. And we were in the other conference room, and it started early, and it went late. But we had constructive input from appraisers that were from all gamuts. And when we left with that, we had a pretty good rules package at that point in time.
And I mean, rulemaking hearing, they're very beneficial. I mean, we just had one for land surveyors, and they actually caught something that the land surveyors didn't, and they went back and changed it because it looked like they were adding another
But
qualification.
if it's just a few items, I mean, if really the only big fish is this thing, and then perhaps the 7 and 3 hour, I mean, nobody's going to be opposed to reducing fees. Nobody's going to be opposed
We
to.
want to
The
eliminate
good thing
that.
is
Yeah.
we're separating
So,
this.
we
so
wanna
we're
I
not
eliminate
gonna-
that part
I
of
don't
it.
necessarily know that we'll be here all day. When ours went all day, we were dealing with the entire package from the very first page to the end of the page, and we went through everything redlined. Took forever. If we're just dealing with 2 components, it may not take that long.
But again, even if it did, I mean, it's everybody's. I think if it's worth it, and I clearly see from the SWIFT that it is, and I think it's been that situation. It's been brought up before and left alone to stay because there was an agreement. So
But
I think
to-
it may be the right way to handle it.
But to
have
do the
it.
rulemaking, we have to agree to change the rule.
Well, if not, there's nothing.
Right, yeah.
Right. So
It's got to
is
stand,
there-
it's got to
We've already
stand.
agreed, and we've already voted on that, it's passed. So,
Yeah.
so,
If I
would-
change my vote, then there's no.
I would
rulemaking.
question that we voted on that. I have a question of clarification. My motion was to take that out and leave it at 100%. We have not voted on component number 2 as it's stated. We accepted component number 1. We have not had a motion to accept component number 2. That was not my motion.
Because we split it after the fact?
We have a split component here. We voted on component number 1, it's gone, and we're through with it. We haven't voted on number 2.
What is component
I
number
did
2?
not make a motion to accept for, as you've got it written there, change
Okay, so-
change classroom to course and add the 50%. We haven't voted on that.
Voted on, and we did a roll call vote on leaving it as 100%,
But we haven't voted,
to go 50. I got you.
Yeah,
we
just
haven't
it.
voted on that component.
Gotcha.
It was because,
I was, you're right.
yeah.
Go to, full, yep.
So I make a second motion that we reject that component.
It's no rulemaking change. That's-
Excuse me?
His motion is for no rule change.
My motion is for no rule change.
And that's why I was confused. That's how I interpreted
okay,
your first
motion's been
motion.
made
Second.
for no rule change, motion's been made and second for no rule change. Any further discussion?
Is there any compromise on a lower number? Is that on the table?
I think Sarah, when she started, it said that, the 50% came up a couple of meetings ago.
Yeah,
and
I'm
that's
going to
why
pull
we-
minutes because
Yeah.
I know it came up.
We didn't come up with it, just, we figured 50 because that's what continuing education is. But, yes, that's open for discussion. So right now, we have a motion and a second
right.
for no changes.
Right.
Are
Mr.
the-
Button, you're going to be out of
Yes.
line just in a minute because we have a motion here.
Now, I'll
Okay.
have to do roll call if it isn't
Okay.
clear what the vote is.
Okay,
Give me
now,
a
the
second.
vote is to reject what is printed on our pad here of the 50/50. Is that correct, Mr. Atwood?
The motion is for no rule change at all on
Okay.
that particular item, yes.
Okay, motion is for,
Qualifying and continuing education.
That's correct.
Okay.
okay, motion is for no change, so we're going to leave it at 100% in qualifying education.
I just heard the words continuing education thrown into the mix. It hasn't
All right,
been
I
mentioned any. Now,
It
when
is
is
just
this?
qualify.
So it's just
Just do
qualifying.
She
because
said- you
continuing.
said continuing.
Well, continuing education is in here for trainees. Because right now our rules say classroom,
Gotcha.
but I don't think
Gotcha.
that's
Okay.
what we.
Okay, does everybody, we have a motion and a second. Any further discussion? All right, does everybody understand what we're voting on? An aye vote will be to reject what has been printed here at 50/50.
Does a yes vote? No.
Yes is
A yes is a no rule change. If we vote no, or if this fails, does it by default say this is what we're going to go with, or we're going to need to have another motion
We
saying
would probably
wanna go with
prefer
this?
another motion to
Probably
go
gonna
with the
have to have another
50%.
vote. Yeah, have to have another vote to see if we're going with 50/50. All right, any further discussion? Okay, all those in favor of the motion say aye.
Aye.
All those opposed? Okay,
We're going to do a roll
I'm
call.
going to do roll call because I didn't hear anything. So 3 didn't vote.
we didn't,
A yes is no rule change.
Yes
In
is-
this-
100% qualifying
yeah,
education.
yes is no.
When you
yes-
say leave it the way it is, are we saying leave
Okay.
it the way it is in the proposed rule?
No,
Or
we-
leave it the way it is right now?
Right now, so if you say yes, it's no rule change. Yes. It's confusing.
Go ahead, Roxanne.
Does everyone know what they're voting for? Yes. Randy Thomas.
No.
Rex Garrison.
Yes.
James Atwood.
Yes.
Mark Johnston.
No.
Jason Bennett.
No.
So we're back to the same 3-2. Thank
So I
you.
propose to accept.
Yeah, we need a motion to accept or to, move forward with the rules as presented or to bring them back for discussion with the whole commission, if that's what you want.
All right, motion to accept the rules as you've proposed them for rulemaking.
With the hearing,
Rulemaking hearing,
Yes.
yes.
with a hearing.
Yes.
All right, is there a second? All right, motion's been made and second to accept the proposed rulemaking change. Any discussion? All those in favor of the change say yes or aye.
Aye.
All those opposed say no.
No.
Roxanne, do you want to vote?
Yes, if that's okay.
Okay.
For the new motion, Randy Thomas,
Yes, I accept the change.
thank you. Mr. Rex Garrison,
No, I don't.
Mr. James Atwood, Mr. Mark Johnson,
Yes.
Mr. Jason Bennett.
Yes.
So we are moving forward for the rulemaking process as
As a hearing.
a hearing, as
And at-
Sarah has
at-
drafted.
At the hearing, we will be able to go back
Oh, yeah, at the hearing,
and
this could
address
go
this however we want.
75%, it could go 25, you could
Okay.
say 100%
It's still up to the
online.
commission, but we'll just have input from,
Yes, at the end of the day, you could have 110 people lined up that say, we think you're crazy, and you can all say, okay, that's fine, we're still going 50%. So,
Correct.
And ideally, hopefully, we'll have all the commissioners present.
we will
Do our very, very
we will
best.
let everyone know that when there will be the rulemaking hearing, that we would like everyone in attendance if possible, because it does make it,
Will it be in July or?
fingers crossed, I can work on this.
We'll keep you
Well,
abreast.
I was just thinking July is a tough time to have something that important.
It may actually be best to go to our.
Push it back to September or whatever month the fall is.
I think after all this and knowing how important this is, it doesn't make sense to pick a month with vacations or low turnout, especially if our members are struggling as well to be able to all make it.
I have just a quick
English.
question.
Yes.
With the remainder of our agenda, how long do you think that'll take?
I mean, I don't know, I have a headache now.
So the proposed complaint expedited process will take a little bit. The rest really is more information, but we have an update to the waiver request. So an hour to an hour and a half is probably realistic. Would the commission like to break for lunch?
I can't be here all that.
Do you all want to, all right, what's the pleasure of the commission? Do you want to continue? Do you want to stop for lunch?
I have one question, though. You mentioned that if we're going to bring in this 4-hour, 7-hour course, we need to do that now?
I would request that if you want to make that proposal, that you tell me to do it right now, and I will add it to this proposal if you think. So that would just take a motion.
I'm more interested in what the consensus is here. I'm throwing it out for discussion, I guess.
I teach that course, and there's really not 3 hours worth of information specific to the state of Tennessee. You really have to stretch to get an additional 3 hours out of that course. So I would be all for eliminating the additional 3 hours and making it a 4-hour course.
I'd second.
I didn't make a motion, but I can.
What does the AQB have anything to say about
It's
that?
4 hours.
It's 4, okay, theirs is 4, okay.
It's for, and
Above, so
Okay.
that 3 hours?
Okay.
the thought process behind that was, like you mentioned earlier, 7-hour courses and 6-hour courses, and you got to get 28. So you're taking a 4-hour course, and where are you going to find a 3-hour course to get your CE? Now, the trainees themselves don't count that as CE, but the supervisors, they do count that as CE. So
God forbid an appraiser would go 4 hours over what he's
I'm just saying,
minimum.
I'm just saying that was the thought process behind that.
Sure.
The unfortunate side, there's more and more 4 hours out there, and it doesn't work with the 7.
Okay. Any further discussion on that? Mr. Atwood, would you care to put that in a motion?
I'll make the motion that we change the supervisor trainee course requirement to 4 hours and eliminate the additional 3.
Second.
Motion's been made and second to change the supervisory trainee course from 7 hours to 4 hours. Any further discussion?
Is that, can that be taken online?
Yes, it can.
Either party or just
Yes.
either party? I mean, is that part of your motion, or is that?
Well, I
allowed?
don't know
The
right
reason it's
now
not
that it
allowed
can be
right now
taken by
because
the
there's no-
trainee online.
Excuse
That's
me?
true. I'm not sure that it can, as the rules are now, you have to have 100%. This is a qualifying education course, so therefore, the
Well,
trainee could not take it online, but the supervisor could.
Okay. That was my question. Can the supervisor take the 4 hour online, and then the trainee has to go to the course?
That's correct.
Okay.
All right, everybody understand what we're voting on? Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you, sir. All right.
When will that go into effect?
It'll have to-
Oh, yeah.
have to go to rules.
We're going to do all that. Okay.
Yeah, you want to take?
We're looking at about
2020.
next May.
Okay.
Yeah.
Okay.
That's all right.
I think it's quit it, whatever we need to do.
Okay. All right, we're going to take a 10-minute break. All right, we're not going to go to lunch. We're going
Okay.
to take a 10-minute break and then we'll work on through this.
Thank you.
All right.
They are bringing some food in here. I bet they do for the real estate commission.
We'll call the Appraiser Commission back to order, please. Writing complaints.
Okay, I'll start this. So I put a little piece of paper up on your desk for everybody. So I'm glad the legal report came the way it did today because this actually helps Roxana and I. What we're proposing will be for first time where they've had no disciplinary action taken, where the reviewer comes back and says, here are the technical issues that I see. And then Roxana and I will discuss what kind of course we could give them. So it wouldn't be discipline. So the first round would be, here's some almost corrective courses without doing the corrective, saying, go take 7 hours of report writing. So how this would work is the complaint would come in. I would send it out for an expert review. I would get the review back. I would go meet with Roxana and say, Roxana, this respondent's never had a complaint filed. They've never had any disciplinary action taken. Here are the notes that the reviewer noted. Roxana and I can call the reviewer at that time and say, hey, if we were going to give a class, what do you think this respondent needs? They could help guide us. If need be, we could call one of you all and say, here were the violations we saw. What courses do you think are the best that this person would be equipped for? I would send out this letter. Well, it's technically from Roxana with me doing the writing. In the first paragraph, we would say it's a condition of this dismissal that you complete a 7-hour report writing course within 60 days of receiving this letter. So this would expedite the process that these would not have to come in front of you all. We would be able to do the first time offenders, get them to take classes. That course would count towards their CE. So it's almost like guided CE. So we can see that you're failing in report writing, so we think you should take this class and try it. If they don't return their completed certificate to us within 60 days, then it will come in front of you all and we will present it like a normal complaint. We will advise you in that complaint that we did send out this conditional dismissal and they did not complete the course required of them, so that you have that background. They can also reject this conditional dismissal, which I can tell you we do one of these kind of for real estate agents for advertising. We kind of send them hey, here's the low end of the penalty that you can sign for and this can be done. Or they can reject this. It comes before you all like a normal thing, and you guys could look at it and say, $2,000 civil penalty or something. You could see something, we think they need to be, another route besides corrective education. So this is kind of, Roxana and I have talked about this. We have talked to the folks in Mississippi a lot, the attorney over there, their investigator. They have an investigator that kind of does their complaints. And they do this, and they've had a lot of success with first-time respondents that actually have minor technical violations. So this is just something we wanted to come to you all. It would reduce the amount of complaints that you all have to see, specifically for these guys that have been licensed since, 1990 and they've never had a violation. This is where we can say, hey, you go take this CE, and you can count it towards your CE. It's not something you have to do as a disciplinary action, and it won't be counted as discipline.
It's not like, it'd be like a letter of instruction.
It's like a letter of
or
instruction.
caution.
The only,
Does it stay in their file, or is it go?
We would keep it in our file just so that we have it, but it wouldn't be anything that we report to the
And when-
National
So then if
Registry.
they get picked up at a later date for a
Exactly.
violation, does
We
it
would
pop
tell
up
you all,
then?
yes.
It would
So
pop
what
up
would
then.
happen
So it
is,
stays in their file.
if you all, the next month, had a complaint against this person, we would tell you conditional dismissal with, a 7-hour report writing course. That way you could know if it was a report writing violation the second time, you all could say, okay, something's not clicking. So,
my only comment to that might be, and I would like to open it to the commission, would be, especially after some of what I heard today, instead of you going back to the reviewer and saying, what kind of course do you think would be best? I would rather for you to pick up the phone and call one of these gentlemen, because I trust them vis-a-vis what I've heard about reviewers today.
and I don't have a problem doing that
Okay.
with calling you or emailing one of you and saying,
Sure.
here were the violations that the expert reviewer found, and this is their first act of discipline. What course do you think is the most fitting?
Right, and I would feel a whole lot better the next time they showed up when you said, Mr. Atwood suggested this course, and they took it and are still committing that sin or whatever, versus you saying, well, the reviewer said, because I've already heard today that we're not, I'd rather hear from Mr.
Yeah.
Atwood or
I don't
Mr.
think either one of us
Garrison, yeah.
have an issue with that.
Is
It
there,
would-
would their name show up? Would there, the information in the, and I apologize, I don't know what that form that you guys send out periodically that shows the violations?
Disciplinary action report that's
Yes.
posted online?
Yeah, they would
So-
not show there.
No, and actually, that doesn't include it doesn't include letters of warning either.
Okay.
What we do with letters of warning, based on a decision by the commission, I don't know, years ago, a decade ago, whenever, was we do post letters of warning, letters of instruction. Those do go on the appraiser subcommittee federal registry, and it was a decision just made by the commission. So if we need to address that, maybe either quickly today or whenever, we just have to really discuss it as a whole and decide at some point, whether it's January 2019, whenever, if that is no longer going to be reported, because that's really not
How does that,
disciplinary.
does anyone know, has anyone ever verified if you pull up an appraiser who's had a letter of warning, does it show that they've received
It
discipline?
says letter of warning, yes, from our state. Now, many states don't report that, but for ours, it would. That is one of the options in the discipline. It's there as an option, so we just pick that and move on.
And I think that's something that Randy and Roxana wanted to address, is that this commission, years ago, like Roxana said, voted on what to send to the National Registry. We're not required to send them letters of warning, letters of instruction. Randy talked to Mr. Park, and it's very limited on what we have to send to them. We really only have to send them revocation, suspension, voluntary suspension, those three, right? So
You could
even
specifically say, we're
could
not
say civil
going to
penalty
send
and
a letter
above.
of warning.
Yes.
Yeah,
or
you could
below.
say the only time that we want to send it to the Federal Registry is if there's a civil penalty assessed or if they've suspended or revoked their license.
And my thought when we talked about it, if the commission's all in agreement with doing that, and we brought it up a couple of times, is to kind of pick a go-live date just because we've got complaints in the process, so we don't, give the person this month and not the other, is just maybe make a decision effective any complaint that comes in effective as of January 2019 or October, because and at that point, we consider it something for them to benefit from this letter as an instruction and not necessarily carry it with them forever. So that's a little bit separate from this, but it's tied together.
Okay.
It goes together.
All right, let's stick on the letter that we have here in front of us then. Sarah, what is your recommendation that we do?
So what I would like is, if you all are okay with this, it would be someone who's had no discipline. So this would be, it has to be no discipline on their record to allow Roxana and I to assess a course that would be a corrective action and to give them a conditional dismissal.
And that no discipline covers no letters of warning, no nothing. You've never seen them or heard of them before
And that's
in the complaint department.
That's what you all can tell me. If they have had a letter of warning or instruction, do you want to count that as previous discipline? Or do you want me to just say civil penalty kind of an above or anything? So that's what I need. That's kind of,
Well, then we'll open the floor for discussion amongst the commissioners.
The,
I mean,
guess
you
the
could say
question.
no discipline or no discipline within the last 10 years. I mean,
Well, the two of the ones today that were recommended for some kind of discipline, we dismissed. So those people wouldn't get the benefit and would be required for you all, especially, I apologize, that one was extensive. And is there a cutoff to say, okay, this person has never done that before, but then you had an expert review done and there is 25 violations in here?
well, and I think, so that's going to be a total judgment call. So I explained it to Randy, and I should probably explain it. So Robin presented today. Robin has a few cases still assigned to her that she will present at the next board meeting. Otherwise, we're shifting back to the old manner that we did this, and I will review all the cases, and I will present them all to you. I will be the only attorney that comes before you all. That would kind of probably be something that I would look at. If there's 25, if they note that many that I think, wow, this is a huge violation, I'm going to bring it in front of you. I'm not even going to consider. So it would. I hate to say that you would make it a judgment call for Roxanne and I, but you kind of would give us a little bit of discretion for if I see something that like jumps out at me, like I think this has to go before the commission, that I would do that. But if I think it's something where they have 3 or 4 violations that I don't think are major, or if I call Mr. Atwood and say, here are the violations that they noticed, and he says, Sarah, I'm not real comfortable with saying, like he did today, that that's a minor violation, then I would say, okay, that's fine, then I'm just going to present this to the commission at the next meeting and go with that. Now, I don't think that's to say that if I present it and they don't have it, that you all still can't instruct me to do this conditional dismissal. So go that route. So if it's not done on the front end, you all can still say, we want to do this on the back end.
Mr. Chair, I would like to applaud this. I think this is really, really good. Appraisers who have a complaint filed against them, it unnerves them. Their life is like they think they're going to lose their license, and their life's going to be over. And there needs to be some consistency, I think, in the way we need to do something. We need to get their attention. But we don't need to assess them with something that will be in their record so long, and it, because on their E&O they have to state every year, have you had any disciplinary action against you, and all of that type of stuff. Those questions have to be answered, so I like it. I would be for this.
All right. Mr. Johnson, do you have any comments?
I only have one other question on the 60 days for the course. We've been over, look, that doesn't seem reasonable to me.
Okay.
Depending on what it is.
I'm okay to increase it. I know normally when we do above and beyond for a regular consent order, we do 180. I'm okay with 180.
Now, since this is CE, not QE, can they do it online?
Yeah.
Yes.
Yeah.
Okay. Yeah.
Well,
That, as we ask our questions early on in the process, that is the main condition. This really has to count toward their continuing education.
And that's what, when I spoke with Mississippi, I think that's where they found they were getting more people that were going along with this, is because now you weren't saying, we're punishing you and you have to go pay to take this class, but yeah, you have to pay to take it, but you're being guided by the commission on what you did incorrectly and where we think that you should be looking at.
Go ahead, Rex, I'm sorry. My comment would be, I'd like to see this, instead of the 180 days, maybe go to 90, because somebody could be functioning for 6 months there, still very deficient, and, you can do a lot of appraisals in 6 months. So that's, but go ahead, you make your comment.
That's what I was going to say. I like the 90 days probably better, because especially with CE rolling and you've got 2 years, if you do 6 months, give them 6 months, that's 25% of the cycle.
Okay. All right. Does someone like to make a motion in regards to this?
I will ask, do you want to do no discipline at all, letters of warning, previous letters of warning at Roxanne and I's discretion on what we think.
I think they get one chance and that's it. And then it comes before the board.
So we just need to go with, if discipline says none, then we're good to go with this. If it says anything else, then we're going to bring it to the board.
Yeah, I like that
That makes
also.
it the
Yeah,
easiest.
you confused me with that because this is taking a class. Are you saying dismiss with a letter of instruction and no class at your discretion?
Past history. That's what we were trying to figure out what.
Gotcha, I'm sorry.
Yep.
Gotcha.
Okay.
I'm still not clear. Are we giving you the power to dismiss?
You're giving us the power to propose a conditional dismissal to them if they've had no disciplinary.
Conditional, but I'm talking about dismissal without conditions. Are we giving you the power to
No.
do that? Okay.
You're only giving me the power of what it says in this letter, that if they complete the course, they can be dismissed.
Right. And in order to take that course, they had
Zero
nothing
discipline.
on there.
Yes,
Okay.
nothing
right.
on their record.
Okay.
Because although it's not discipline, most of the time when we present to you, we tell you when there's letters of warning in the past. So although it's not technically discipline, when you get the list on the legal report, it comes up as history. So
Now, let me ask you a question before we vote on this. Will this show on their history as far as this is not going to be considered as, quote, discipline?
no, this will
Okay.
not be discipline.
Okay, so would someone like to entertain a motion that we accept this as we have discussed?
So moved.
All right, we have a motion. Do we hear a second?
Second.
Okay, open for discussion.
I'd like to make an amendment that the time frame is modified from 60 days to 90 days.
Okay, we have that, yeah, that's the way she had discussed it with 90 days. Okay,
Perfect.
so the motion and second on the floor is for this letter based upon a 90 days receipt of the taking the class 90 days and the fact that they have nothing on their record previously. Okay, that's what we're going to vote on. Any further discussion? Everybody know what we're voting on? All those in favor say aye.
Aye.
Any opposed? All right, Sarah,
Perfect.
we'll take that.
No,
to
these
90
are good
days.
steps forward.
Yeah, this is going to be a good step forward.
And this should really, I mean, looking at the legal report today, this would have almost cut it in half. I mean, so,
Now,
since you talked about
is that finished with complaints?
It is, we're on the director's report.
Okay.
If that's good with you, and I want to take into account, Mr. Johnson, if you're going to be leaving us, I can skip a little bit. Do you know how much longer you're
No,
going to?
I'm good right now.
Okay.
I'm good.
So on the director's report, we're starting on page 66. The first thing that I did want to present to everyone was the last 4 years of expenses and revenues, just to have a look, and this ties in with the fee reduction we've approved. I'm going to take a closer look to the fee reduction, make sure that everything needed to be included is there, that it's very clear. But at the very bottom of fiscal year 2016-2017, you'll see that we ended with $2,080,994. And so that's that excess that we were talking about. The next page is the report that I've presented at all of our meetings. This is that new view of revenues and expenses. And so far this year, we've added to that $252,135. $232,135. So we took in $547,000. We've spent $295. So it'll take us a minute to feel the reduction in that fee and start slowing down. But this also has the way that our director for finances does it. The cost back is estimated at the bottom of this, so it's getting more realistic. We don't.
Roxanne, I don't remember. Did the Senate give us a time frame?
No, we've been continued for the 4 years.
Okay,
from the
okay,
sunset
so it's
hearing,
4
yes,
years, okay.
Yes. So this is our current surplus, and the fee reductions will help. I don't know that the other pages you need to necessarily look at, but I wanted to make sure that you saw a breakdown of the expenses. That's the next page. And then revenues are our breakdowns of the appraiser fee, and then the separate line is our separate complaint number. So those are our expenses, revenues, and I'll present those at each meeting, just especially once the fees go down so we can take a look at that impact. Questions?
The fee in here, does that fee does not include, that fee includes the AMC fee?
Yes, our revenues include everybody's. We don't separate the AMCs from our.
Do you have any
real estate
idea
rates.
what percentage is which?
I don't, but I can find that out for you. We've got 155 registered AMCs as opposed to the 1,833 other
AMC
appraisers.
fees 2,000 every 2 years.
Yes, yes. So I can definitely get that for you, Mr. Bennett, just so you have an idea, and I'll present that. What part of the revenue constitutes?
It doesn't matter, honestly.
No, that's not a problem.
Okay.
Because it's interesting to me once I hear a question that doesn't stand out. So I will definitely present that. And that's all I've got for our budget report. No reason to, like I said, once we're addressing the fee reduction, I think slowly we'll start seeing that level off. I wanted just to make sure that everybody knew we did the National Association of Appraisers. Their conference was here in Nashville. Sarah and I went. Your chair was there. I got a chance to speak and kind of present some of the numbers that we had. It was very, very good. They all over, so that was very interesting. I think it was the first time that they were here. Am I correct?
First meeting they've had.
First meeting that they've had.
Yeah.
I think they had about 120 or so individuals. So it was interesting, and we attended it. You have on your iPads on page 71, and I'll be happy to email this letter to you. This is a follow-up letter regarding the waiver request that we had. I'm going to give everyone a minute to read it if you haven't had a chance to. It went to Jim Parks, and he forwarded it to us, and I know that because Chairman Thomas was also on it, he's had a chance to look at it. We've not been asked to respond to it at all, so as of right now, it's just review information for you. I did respond to the email and just said that, of course, as the commission office, I'm more than happy to get any kind of numbers that they might need, answer any questions regarding, where our licensee pool is located, anything of that sort. So I'm available if they've got questions regarding that.
And they meet next Monday.
Oh, and they are meeting in D.C. next Monday. So Randy Thomas is going, and he's asked questions.
Anybody have any questions, comments about the letter?
I found it very interesting that where he said we had better access to the database than he did. That's all a public records request, just so everyone on the record can hear that. They could have gotten these numbers just as easily as we did.
One thing that concerns me is, of course, my name's on there.
I know, I was like, I thought my letter was really good.
In their initial request, they did not delineate between residential and commercial, and now they're saying, "Oh, Mr. Thomas refers to residential," and when you correct me if I'm wrong, but in their initial letter, it was just, "We want this carte blanche
Yeah.
waiver."
No, it did.
So, okay. Anybody else? Alrighty.
And this may fall under the new business that we were going to discuss, but as of Friday, commercial evaluation threshold for new money has been increased to $500,000. I would imagine that covers a large portion of their business.
Good.
Talk
Okay.
about the National Registry.
I do, and I've left for you, I think, the last document on your iPads. You don't need to review it. You can skim over it. This is the final updated version, revised in 2018 for the Appraiser Subcommittee. Just as we're discussing, the next conference in Seattle, Washington for Aero is Mr. Thomas, Rex Garrison, and Sarah will be going. At that point, I believe the final pieces to the AMC changes with the audit and those kind of things will be discussed. And so our rules have gone through already, right?
Yes, our
Yes.
rules will be effective as of June 19th, 2018.
So our rules, yeah, will match the changes. We'll be ready to go. I think one of the things that will probably be discussed there one more time is the audit piece. We currently already have everything in line for the AMC. It'll be a matter of adding them to the federal AMC registry, like we do all of our other real estate appraisers. It's the audit piece that will be brand new. So I wanted us to kind of have a conversation of the plan with auditing those records. We could do audit everyone and ask for all the records to be turned in, but I believe we have the, and you can correct me if I'm wrong, or we can do more research, we can audit just a certain percentage of the renewals from our AMCs, and I think that would definitely help the office as far as manpower hours to have to touch the records and see what comes in. Accountancy, architects and engineers, which are now one of my programs, instead of looking at everything and automatically looking at everyone's CE and everybody's documentation, once the renewal cycle goes in, the system, our system now has the ability to have a set percentage automatically be pulled. And so I would like to go that route. Unless something comes up at the conference you all attend where there's been a change and we have to audit everyone, I think I'd be inclined for us to pick that 10%, let the system randomly pick it, send out a letter to the AMC company and saying, you've been selected as an audit, now you need to send us your records. And then that's what we actually review to make sure that it's in line with the fees we start collecting.
Question on that?
My only question on that is the renewals and when they're coming in. The initial requirement to be licensed was, I think, in June or July. I can't remember off the top of my head. So I would imagine a vast majority of the renewals are going to come in the same time frame, and then the rest of the renewals, throughout the year, the numbers will be dramatically smaller. So, I'm not obviously real crazy about the whole audit piece of it to begin with, but how are we making sure that an adequate number is being reviewed and looked at?
I think if the commission agrees with 10%, and I'm just throwing that out there because we're doing that in several of the other programs. So if it's the vast majority, so of the 155 that we have licensed, 130 renew at the same time, that makes it a little bit heavier from a work perspective for the office, but we'll deal with that. We pull people off one program onto the other is how I've been having to do it. And so we're going to audit based on the renewal cycle. When the renewal cycle stops and it's 130 versus the other 25 spread out, it's still the same 10%. So depending on how many renewed, it would be 10%. That way we know we're fair.
The current audit requirement would be, you said you have 100 appraisers on your panel. Match the names up.
Match the names, send us your documentation. We would make sure with the AAC that we haven't missed something. What exactly does have to be in our records to show that we audited and looked at the right things? Since this is all new, I'm actually going to make sure that we ask in our letter for exactly what needs to be turned in. And that becomes part of the license file with that AMC. And so with other programs, what we do to not audit you back to back, we could, but in reality, it'd be nice to not audit the same AMC company every 2 years. And so we can program the mathematical equations one way if the license ends in a odd number or even number, that kind of thing, to where we eventually audit everyone.
Any further discussion on this? What's the pleasure of the commission?
Are we on new business?
We're on the AMCs.
All right, well, I'll wait then.
What we want to do on the
I thought he was going to dismiss.
what we want to do on the AMCs. He thinks we needed it.
No.
Okay, the vote was four to one.
I guess a motion to accept 10% randomized.
All right, motion been made to accept
Second.
10% randomized, and second in regards to the audit of the AMCs. Any further discussion? All those in favor, please say aye.
Aye.
All those opposed? All right, Roxanne, motion carries 10%.
Thank you. And we will finalize what documents we need, the letter, something like that by July, since it will have kicked in. That doesn't mean that we'll have, renewals already there in the pipelines, but that way the commission's kept abreast of what we're doing. And again, it's every 2 years, so hopefully we'll be able to rotate these and keep it simple. So that is all that I have, I think. Open for new.
Anybody, well, how about old business?
Okay, old
Anybody
business.
have any old business?
One question on evals.
Yes.
Oh, okay.
Is that up and?
Yeah, go ahead.
It is up
We'll
on
bring
the
it under old.
website, and we tried to make it, I think it's under news information, so I can send everyone a link again. I think when we posted it, I sent out an email saying that they'd been posted it, but I have no problem sending it again. We haven't gotten, that I know of, any calls or concerns or questions because they've read it and are confused, but yes, it's been posted online. We're good, yes. And the frequently asked question piece also includes it in there.
Under again, one more time.
I believe under frequently asked questions, we put them right on top. And I had originally asked for it to be under the news and new information, so I'm going to see if it's under both, and then I'll email everyone today or tomorrow, just reminding you and sending you the link, so you're not searching for it.
Anyone else under old business? I have one thing under new business that I wish to bring up to the commission, and that would be, we have talked with states from across the country, and I would like to propose, in regards to USPAP, that we require USPAP to be taken in the first 6 months of the renewal cycle. And this is my rationale. Number one, it wouldn't go into effect until January the 1st, 2020, which will be the next cycle of USPAP. And it will be required within the first 6 months. However, as everyone knows, USPAP courses come out in October, so you actually have October, November, and December, plus the first 6 months. I have spoken to several providers of USPAP, and they don't have a problem with that, because the reality is, under the staggered licensing, you might have a USPAP course that doesn't have a whole lot of people in it in the latter part of the 2 years, so that we don't have someone who shows up in front of us in November of their second year and say, well, I haven't taken the USPAP course yet because I don't have to have it. And then they take a USPAP course and it's good for 30 days, and then they're responsible for the next. But there are a number of states out there that require that you take USPAP in the first 6 months. And I don't have a problem with that, because it would actually be 9 months instead of 6 months, because of the courses come out 3 months in the old year. So it wouldn't be applicable until January of 2020. So I'm not putting that in the form of a motion at this time, but I would like you to think about it, and maybe in July we could vote on that. And as a provider of USPAP, what do you think?
Unfortunately, a lot of appraisers wait until deep into their 2-year cycle to take the current USPAP that they should have already been familiar with for 18 months, but they didn't take the course until at the end. So I think it would encourage, it would require, mandate that they take the current USPAP at the beginning of their cycle, which is where they all ought to be taking it anyway. So I would be for it.
It's one thing I've talked to Roxanne on, and this is more, I guess, what AQB or whoever lays it out, far as if you think about when USPAP comes, the new USPAP comes out, it comes out in the, what is it, the beginning of when licensing first came out, a lot of the guys that were appraising at that time got their license that fall before they had to have it. So their renewal cycle is in the latter stage of when the new USPAP comes out. So they're caught in a quandary of, well, if I take his USPAP at the end of my cycle, it's not going to count for the new cycle. And, you know, there ought to be something to allow USPAP, an exception, to allow USPAP to be taken early, or it would count, say, and I'll give an example. Say their renewal cycle is December 1 and coming up December 1 of 2019, and the new USPAP comes out in January of 2020. Well, they can't take USPAP until after December, whereas it may be offered and they're close to them earlier, but they can't take it because their license renews December 1st. So they're in a quandary, so they have to wait until after they renew their license to be able to take USPAP. And there's got to be some kind of exception to that.
I'm trying to figure out how. So I think under what Randy is saying, they should have taken the previous USPAP.
Well, no, what I'm saying is they want to take the new one before it actually goes into effect.
They want it to count on the renewal
and we're
before.
penalizing them because of their renewal date from taking it before it actually goes into effect. And in an under ideal situation, USPAP would come out in September. In an ideal setting, July 1 of the year before it goes into effect, and you have 6 months to get it before it goes into effect. Then you know the rules before you're actually appraising. But that's not how the cycle rolls.
But that's why I'm saying
And-
you can
and
take
I
it.
agree.
You can take it in those first 3
Well,
months.
but the problem is if they renew December 1st and
Right, I
it's
see what
being
you're-
offered
right.
right then, they can't
Right.
take it. And
So that's why I'm saying I'm not asking for a vote today. I'm just
Right.
wanting, let's get it ironed out. But I do think, like you, I think you should take it at least in that first 6 months
Yeah.
so that you're operating
Yeah.
18 months under the current law, because like what I said, Mr. Atwood said, you got guys that are taking it in November
well,
and it runs out in January.
I totally agree.
Yeah.
I'm just saying, in with that, we need to not penalize those guys
Exactly.
that want to take it before it goes into
Well, that's-
effect
you're exactly
because of
right.
their licensing.
Right. I don't know how we do that, but that's something we need to work out.
Could you not have something on their license where it says they've taken the current, the 2020 USPAP update, checkbox, something to notify that, so it's counted for them? I mean, I don't
Mind that people renew the entire year, so we're not, just talking about the ones that are coming in January and
But
February.
there's a big chunk
But the
of
ones,
those low numbers.
Yes, yes.
well, yeah, that's right. I mean, but like mine renews in March. So it doesn't, it's, if I just take a normal cycle, I'm always going to be in sync.
Yeah.
But yeah.
I'm not, well, and we can look at everything. I do think if we mandate that they take it early on between October and those first 6 months of their new renewal cycle, am I saying it right?
Right, which
Well,
would be a total of 9
yeah,
months.
If they've had USPAP and they've had their 28 hours, at least 28 hours, and they take it the month of December, can we not just, or, right within that period of time, can it not be included?
My understanding, that's an AQB requirement.
Yeah, that's
So-
what, and that may be something, I don't know, we talk about trying to track somebody down.
I think
In Seattle,
we may
I-
have to talk to our AQB people just to see
Yeah.
how that would work, because I always hate to default to computers in the system, but this is going to be terribly complicated for Brad and Roxana to have to track if someone's done something in the first 6 months. I mean, I don't even know.
Have to have some kind of tracking.
I don't even know
so
if we
if
could set
someone
a
didn't-
modifier on it. Yeah.
No, that would be a nightmare. And with our new system, what we encourage people to actually do is not send us your continuing education until you're renewing, because in essence, we shouldn't have to worry about the 1,833 people renewing until it's time to. So with that
don't have to
having
worry
been
about
said,
it.
we won't see what you took right after you renewed until the next cycle. Now, if we added it here, when you renew, you could vouch, I took what was expected of me based on the statute and put it in the statute, and then we hold them accountable for it. And we decide if we do an audit or not, but the office would have a hard time checking up on everybody doing it right after they renew, because in essence, nothing flags us to look at your license after you've renewed. We look at it only to make sure that you met the requirements to renew you.
That's why I said put it off until
Yeah.
January 2020, so everybody goes
Well, and
through this cycle.
We don't want to put it off till January 2020 because this is going to have to be a rulemaking update. So we are going to want to be able to put this
I'm
in.
talking about the actual implement.
Oh,
of
no,
it.
I agree. But,
Yeah.
I mean, we're going to have to start this at like 9 to 10 months out. So
Sure.
February of
but
next
it's just
year.
something
and-
I think it would be important because I think a lot of people are using it as a crutch to say, well, I didn't have to operate under. Or in my mentality, I didn't have to operate under USPAP because I haven't taken the course yet because I'm not required to.
You need to read the first page.
Well, I understand that, but you got unfortunately, you got a section of appraisers out there that all they're interested in doing is working.
And I mean, until then, preach it. I just tell everyone that you know. I mean, when you're talking to new appraisers or someone that wants to be an appraiser, to take it as soon as possible when they can, when it comes out. I mean, I don't have a problem sending out an e-notify when we put out something new that says, please be aware that the new USPAP course has been, out. Please take it as soon as possible. Or the commission advises it is in their opinion that you should take this within the first 6 months. Maybe it's not, maybe we don't try a rule change immediately, but we, say that your great minds are telling them to, try to take it as soon as you can so that you're operating under the correct standards.
Food for thought.
Great idea.
Anything else?
Yes, sir. I don't really want to beat this thing to death, but it's really concerned to me, the quality of the review reports today, or in some ways the lack thereof. So what I would wonder on the record is, do we need to have some type of training, or and that could be a 2-hour deal, 1-hour deal. Just have all the reviewers come in, and one of us or somebody like Danny Wiley or somebody address them and say, this is the kind of things that are needed in this, maybe a scope of work deal. What is their scope of work? That way, everybody's kind of doing it on the same page. There were some opinions given today that were unsupported and even inaccurate. And actually, that information is not helpful to us whatsoever. Whereas knowledgeable reviewers who know USPAP and are actually looking at the reports from a USPAP compliance standpoint. But I don't know if the reviewers that we have, I would assume none of them are probably USPAP instructors, and not that would necessarily be a requirement that they be a USPAP instructor, but they certainly need to know it. So I don't want to sit here next commission meeting and get all frustrated with the review reports.
Well, it might be as easy as putting together a scope of work. You could do it, or anybody could do it on the commission. It says these are the things that would be helpful to us, and then let them give them to the reviewer and just say, make sure you incorporate this into your report.
I think that would be the best first step. And I mean, Commissioner Atwood, I know that you've done reviewing. Maybe you take the lead and draft up
I
something.
knew by bringing this up,
I know,
I'd get stuck with
So
that.
you get yourself in trouble. But, maybe you can draft something to Mark's, comments and bring it before the commission in July. And then when we send it out, all those reviewers can have that, just some basic questions, because, I can't train them on USPAP, and I do deal with them on a regular basis. So if I had some guidelines where I could tell them, here's what we're looking for. The only other question I had that I wanted to get on the record to make sure that you all are in agreement with is that if it's a residential property that's in East Tennessee, can a reviewer that review in West Tennessee review it? Do I have to use the review? Residential properties, can they be reviewed by any of my experts in the state?
Depends on the scope of work. Yes or no?
Well, they have to have geographic competency.
Not necessarily. Now, if
That's
they're going to say,
that's our biggest issue that we're having right now.
if they're going to say the boundaries were inaccurate, they better have geographic competence. If they're going to say they picked the wrong comps or these adjustments are incorrect, they better have geographic competence. But if they're not being required to make those conclusions, but to say this sales comparison adjustments were not supported in violation of Standard Rule 2, blah, blah, whatever it is, they don't need geographical competence to make that statement.
So, and maybe this is ignorance on my part, but somebody that has access to the MLS, could they not pick comparables in another area of the state, or do they?
No, they cannot. They should not.
Because see, that is our biggest issue right now, is when I have a complaint coming from Middle Tennessee, I have one reviewer, and if he has a conflict for any reason, then I have no reviewers.
Definitely need more reviewers then, because
Well-
I think it's foolish to have a reviewer out of area do a review.
I would prefer, if I'm in East Tennessee, I want somebody with that area to know it.
Ideally,
And we
that's
normally
what you
have
want.
3 in each.
We-
But we've sent out an RFP twice now,
Yeah.
and we're not getting any
We have
responses.
4 total, and that has been begging, pleading, calling in
How are they-
person.
How are they paid? Is it certain, is it a flat fee or,
And how does the state pay?
no, how are the review,
I'm going to let Commissioner Allen answer this. He
I
may be the
might
best.
want to be a reviewer and get off this board. No, I'm kidding. No, I'm just wondering. Yeah.
We might want you to be a reviewer and get off this board, too.
You respond to their request and you put down what you're willing to be paid for it, and they agree or not agree.
Okay, so
They
you can
send you a
vary.
letter of engagement.
That's
So
correct.
reviewer A may
For 1 year.
charge X, and reviewer B may charge more than X, and it's not like,
It's not like a flat fee. It's not like
it's
every
not
review
like
you
we're
do.
paying every reviewer X.
It would
It's
be
not
much
like that.
easier probably if we said
But having said that, so we've got a team, an attorney that does this, handles contracts. We don't have, no one's paid $100 and the other $2,000 for the same job. That's not the case. But given the experience, all that's taken into account. If they're working on the entire complaint versus per hour, that can be worked out as well.
Now, do we have any people that live out of state that are reviewing?
No, not right now. So another thing that, since we're talking about food for thought and homework, if you will, for you all to take with you is, I think, at least definitely Mississippi, maybe a couple other states have actual in-office hired staff that review all
That's
the
what
complaints.
I've wondered, at least on a initial response to the complaints, handle some of it, especially considering we have a $2 million surplus.
I mean,
Don't
Could
say
you
we got
use-
$2 million.
Yeah.
I'll take that job for $2 million.
no, I get a pay increase first on that $2 million.
So it's something that I can definitely, if the commission is interested, I can look at it, talk to assistant commissioners, see what all we would have to do to propose it. The question then is there one person that would be qualified to do the entire state and just, have the,
I think that's a situation, they can handle the USPAP, and if they need something
Okay.
in a geographic area, that's when they subcontract it out.
You may end up saving money.
Yes, exactly,
And
exactly.
we do, I'd say, thousands of USPAP compliance reviews a year, and we've got a 100-question checklist. So as a member on the commission, it'd be super helpful to be able to look at that when a complaint actually comes in and look at those questions to say, this is where your deficiency was.
Well, and I mean,
And that would be consistent.
For me, as somebody that's just getting a review back, I mean, I don't think I'm completely ignorant of appraisal standards, but if that reviewer tells me that there were these violations, it's hard for me to say that wasn't the case unless I go dig through the appraisal report and try to decipher it. So I hate when we come before you and you're like, that's just crazy, because that's what we're given and they're supposed to be the experts, and it creates an issue for us. So,
That's not your job. That's what you hired them to
yeah.
do.
But it would be easier if
But-
I could come back and say, hey, of that checklist, they told me, they didn't have X and they didn't have Y, and you've said in the past these are big deals and these are not big deals. And
Mr. Atwood has agreed to put together, I asked him if he would put together some kind of a checklist or a scope of work that we.
I got one right here.
Yeah, a scope of work that
I think we have a committee.
we're sort of expecting, yeah. And so let's just take those as food for thought for now, and we'll see what we'll come back with.
put that on the agenda
Yeah.
for next month
Yeah.
so that we can.
I'd make a motion that we put a subcommittee together of Jason and Jim to compile this
second that.
checklist and bring it back at the next meeting.
Just don't communicate with each other about this outside the meeting.
All opposed, aye.
Roll call, please.
Anything else from the commission? Do I entertain a motion
I
for
move we adjourn.
adjournment? Do I have a second?
Second.
All those in favor, leave.
Aye.
2 o'clock, gentlemen. Thank you. Yes, please, thank you.
Jason, your checklist, this is something you would share?
Yeah, Randy helped develop it.
May drive
We all use it together. We use Randy for.